Okay. And just sum up what actually happened. You referred to your having been sent a copy of a Mail and Guardian article. Who sent it to you?
It was, amongst other people, Mr. Henk van der Heever.
Yes. And if you turn, please, to page 622.
622.
On the about halfway down, there's an email apparently from you to Mr. Burger.
I can just, 622. On it, yes.
Halfway
I
down.
found it.
And you refer him to that article. And
Yes.
you just read out what you say. Is the president? Just read that out, please.
I'm sorry, reading from 622?
622.
Okay, all right.
Halfway down, Chair.
Dear Stefan, please see the attached article below. Is the president and his family/friends allowed to benefit from SOE procurement contract? If it is indeed true that the president has association with VR Laser, I believe that VR Laser should have declared their interest in this regard. I recommend that we request VR Laser to disclose the real shareholders behind their black equity shareholding. Can we please have a meeting tomorrow when you are back in the office to discuss the way forward? I cannot have any further dealings with VR Laser until this allegation has been cleared.
Now, is it correct that the article is attached on page 623 under cover of an email to you from Mr. van den Heever that you mentioned earlier?
That is correct.
Now, we don't need to go into the detailed contents of the article. Just summarize what concerned you about the article. What was it saying that rang alarm bells for you?
It was essentially stating that VR Laser had connection to the president and they were benefiting from state-owned procurement contracts, in a nutshell.
Your affidavit refers to allegations of connections with the Gupta family and also Mr. Duduzane Zuma.
Exactly.
Now, if we keep at that page, 622, we see what appears to be a response from Mr. Burger at the top of the page, and he says, 100% Celia, our dealings need to be squeaky clean. And then he refers to arrangements being made for a meeting to discuss as you'd requested. Is that right?
That's right.
Okay. Now, what happened thereafter?
Thereafter, I can't remember exactly what the exact details of the meeting, but we agreed that I will send a declaration of interest form accompanied by the letter asking them to declare their interest, if any, because we didn't know if the allegations in the newspaper article was true or not.
If I can take you to page 632.
Found it?
That's a letter with your name and signature, is that correct?
That is correct.
I'm battling to see who it is addressed to. There's an address that is inserted, but there's no name of the company or person to whom the letter is.
It's addressed to the address that you see there, 10 Haki Road. In Johannesburg is the VR Laser address, and
Right.
it says attention CEO, and it was emailed to VR Laser.
Right, so was it sent to VR Laser?
Yes, it was.
And did they respond?
Why didn't you include VR Laser's name?
It was just an oversight. Yeah.
Okay.
Because if you look at the reference, it actually starts with VR. It was just a simple oversight. But
Okay.
if you look at the content of the letter itself, it does refer to VR Laser.
Okay.
Then if you can turn please to page 634, And tell the chair, please, did you receive a response to this request for a declaration of interest
Yes, I did.
from VR Laser?
Yes,
And is that what we find at page 634 and 5?
that is correct.
If you look at the letter, 635 says, the second paragraph, we confirm that the shareholders in VR Laser Services are Gasol, Pty Limited, 74.9%, and Crayshire Investment Pty Limited, 25.1% are the shareholders, and neither have any involvement or conflict with doing business with Denel in any way whatsoever. All shareholders and directors are private individuals who do not work for government. Were you satisfied with that response?
If you look at the full declaration, without necessarily referring to the last part, I was satisfied. But furthermore, there was a clause in the contract stating that should they later be found to have been unethical or lied, we can terminate the contract at any time. So I was satisfied that with this document that I have, if they've lied, then we can terminate the contract to protect the company.
Now, if you turn next to page 637,
One yet?
this is an exchange of emails between you and Mr.
Mulambo.
Mlambo. The one at the bottom is from Benny Gianni to yourself. He's the Chief Operating Officer of VR Laser. Please find attached letter and a completed declaration. Are those the documents we just looked at?
That is correct.
And then in the middle of the page, the email from you to Dennis Mlambo, you've already confirmed he's the Group Head of Procurement Supply
Correct.
Chain, who will be our next witness, Chair.
Okay.
You then say, Dennis, please find attached the ownership details as requested. Had you had any dealings with Mr. Mlambo at group level in relation to this issue of ownership and possible conflict of interest?
Yes, we used to have a lot of informal discussions with regard to VR Laser and my satisfaction with it, off the record. And in some cases, I will send him emails and delete them, but on his side, I don't think he deleted them. He would have them, I think.
And then you appear to respond he appears to respond to you at the top of the page on the 2nd of September. Thanks for the info. Who are the individual shareholders of Gasol and Crayshire? So what you'd been given was
Company.
information that Gasol and Crayshire were shareholders in VR Laser, an assurance in broad terms in the letter that nobody worked for government and there was no conflict. But Mr. Mlambo was then saying, but let's find out who the owners
Let's probe a bit further.
Yes. Was anything done by you following up from that?
No, Mr. Mulambo took it over and he CC'd me on the emails to VR Laser probing further.
And Mr. Mlambo will deal with this in his evidence, but you say in your affidavit, Mr. J.P. Aurora confirmed that Gasol, which had a 74.9% stake in VR Laser, was owned by Salim Essa. So that was what came out of Mr. Mlambo's exercise to find details,
Yes.
not yours. Right. Thank you. Now can we turn in your affidavit, page 158, to another agreement. This is a new topic we need to cover with you.
Okay.
And that is a single source supplier contract that DLS awarded to VR Laser in 2015.
Correct?
Now, I'm just going to, if I may, Chair, just to skip through a couple of paragraphs that appear to be more background that you will be
Okay.
able to read that.
Okay.
Relating to technical input and so forth. And may I skip then to page 159, paragraph 5.3.
Yes.
Now, you'd mentioned in the earlier paragraphs that you'd been asked to deal with the procurement side for a proposed contract for sole supply, single source.
Yes, that is
And-
correct.
And you deal in paragraph 5.3 with a a requested draft submission. So were you asked for a submission, to prepare a submission?
Yes, I was asked to prepare a submission, and it's all in writing in the emails that you see here.
Right. And you made a recommendation. Can I take you to page 651?
651 at the break. Six, 5, 1. Got it.
Now, that's a brief email from you to Mr. Turbis, and it's got the subject Group CEO submission. Please find the attached document as requested. It's just the email. It seems that the attachment hasn't been included in the copy that has been raised, unless it's the document. Perhaps you can help me, Ms. Malashlela. Is it at page 654?
I just need to double check. Yes, it's the one, because in the recommendation I had included a note.
Okay, thank you. Sorry about the confusion. Now, you made a recommendation to go out to tender for this contract.
That is correct.
And why did you recommend that?
We couldn't appoint or contract a supplier without following a process.
Right. At this stage,
Okay, I'm sorry. Now, that is a tender in relation to, that's in relation to which tender? I just want to, we
The
have
MOU.
moved away from the one that we have been dealing with the whole morning, isn't it?
yes, we've moved away from that, Chair.
Yes, which
And-
one are we on now?
And if you will look at the heading, Chair, to paragraph 5 on page 158, it deals with the memorandum of agreement
Oh, that's the one we are dealing with now.
2015. It's a single source
Yes, okay.
sole
okay.
supplier contract
In favor of the same company?
in favor of the same company, but it is a different transaction.
Yes, okay,
Yes.
all right.
So
And this one is to do what?
well, can you just confirm, Ms.
Malashela.
Malashela, if you look at 5.1, it's for the appointment of what?
5.1, which page, sorry?
Sorry, page 158.
158.
Or it's for the supply of turret FCMs, hulls, and related armor steel components, is that right?
Yes, it was complex fabrications,
Yes.
steel fabrications.
Okay,
And you start that wording with the word single source.
That's
supply.
correct.
Right. Is there any significance to this being a contract for a single source?
So I received a request from engineering, I'll call it engineering technical, substantiating why there is a need for for having a single supplier to assist them with fabrication going forward. So this was submitted to me, and Rhiannon asked me to, Mr. Tiebers asked me to do a motivation. But in the motivation, instead of having the name of the supplier, I wrote that a proper process should be followed if that's the strategic decision that the company wants to take, and it should not be longer than 3 years.
okay, the earlier transaction was also for the supply of hulls, eh?
That one was just for her. So essentially, this one, my understanding was that it was going to cover a whole lot of different fabrications on different programs going forward.
Yes, but basically it's also hulls, just like
It's
different brands.
yes,
or
steel
different brands.
plates and different stuff, yeah.
Yes, yeah, okay. And then the steel components and so on.
Yeah, that's why I'm saying that it went beyond just house. It was a lot of
Yes.
steel components,
Okay,
complex
all right.
fabrications.
Thank you, Mr. Kennedy.
Were there various manufacturers in the marketplace which could compete for this type of product?
That is correct.
Once one of them was awarded the contract, it would then be the only supplier to Denel of those components
For the duration of the
for
contract.
the duration of the contract, yes, which you recommended should be no more than 3 years.
Exactly. After having followed a proper process in the selection.
Yes.
So, would it mean that you award the contract or appoint a particular manufacturer and say to them, for this particular period, you are going to be our only supplier of these materials?
That is the understanding, but we had not discussed that up to that detail at that particular time.
Yes, no, I'm talking at general to say, when you say somebody is going to be a single supplier, is that what it means?
Yes, it's a single
That
source. You
for a
only-
certain period, they have exclusive right to supply you with whatever?
That is correct.
Yeah, okay, all right.
Now, I mentioned earlier that the attachment hadn't been attached to the email, at least in the copy that we have before the commission. Can I take you in your affidavit? I don't need to take you to the actual paragraph, but you refer to Mr. Turbers responding, and he changed the submission document.
That is correct.
And I may have confused things earlier when taking you to that document. If I can take you back to page 653.
656. On it?
That's an email from Mr. Turbers to yourself, 20 March 2015.
That is correct.
And he says, I've changed the angle that we ask for approval from Riaz. Please see attached submission. Is this the document that came back from Mr. Turbers reflecting a change?
Yes, you are actually right. I see now VR laser is already included. My recommendation did not have the name of the supplier. I would like to put that on record that the initial document that I sent to Mr. Turbers did not have the name of the supplier, which is VR laser, which he then inserted as part of the response to me saying that it should go to Riaz.
The initial document that you prepared didn't have VR laser because you were saying it needs to go out to open competitive process.
That is correct.
Would that be a proper public tender?
Yes. If you also look at the timing of this particular submission, we were then using the new policy that we must just check, was based on the group policy that called for open tender.
Can we go to the document you sent to Mr. Chivers that didn't have the name of the supplier? I think I missed that if you have already dealt with it.
Chair, I'm afraid there appears to be a problem.
Oh.
In that what appears at page 651 should have an attachment
Yes,
attached to the email.
yes.
The affidavit, in fact, says that it was attached.
Oh, but
But
it's not attached.
For a reason that I'm afraid I don't have information to convey to you now.
Yes, okay. And
the-
that would have been the document that
It
I'm
w-
looking for.
It would have been what should be here is the original version that the witness prepared.
Yes, yes,
And I
yes.
confused her by assuming that it was the document at page 654.
Okay,
But
okay,
she's now clarified that in fact, it was the revised version as revised by Mr. Tubis.
okay, no, that's fine.
And Chair, may we just request leave, once we track down that annexure that for some reason hasn't been included in the pack,
Yeah,
we
you-
may
you-
we may
yeah.
present that to
Yeah,
you.
let's do that, and then for the record, you can just announce that it's been found and it's been included, and it will be page whatever.
Thank you, Chair. I'm sure
Yeah.
my learned juniors will
Okay.
assist
If
on that
I
score.
may just, as a follow-up to my last response, we can get the policy, under the new policies and procedures, there were circumstances where we would be allowed to follow a closed tender and in circumstances where we would follow an open tender. And it's all
Yes.
stipulated in that policy.
Yeah, okay.
Now, sorry, Chair, may I continue?
Sorry?
May I continue?
Yes, please.
Thank you, Chair. Now, you say that Mr. Tubis, he came back with a revised version, which now recommended not that it should go out on open tender, but that it should be awarded to VR Laser.
That is correct. The name of VR laser was already in the submission when it written.
If I can take you to page 656.
656. Got it?
In paragraph 4, what appears is recommendation, DLS, based on the supply chain process followed for the Hoefeyster vehicle and the AV8 turrets hulls to date, and that both these processes are or will be industrialized at VR Laser. It is recommended, it should read, that VR Laser is appointed a single source supplier for fabricated structures for a period of 3 years.
Correct.
So Mr. Turbis agreed with your recommendation that this contract should be for 3 years, but he didn't accept your view that it should go out to tender. Instead, it should be awarded immediately to VR Laser.
It appears.
Prior to you receiving this submission or recommendation from him, had he had a discussion with you with regard to his different view on that?
And no, the only discussion that I had with him was when he came to my office, alerting me that there is this request that's going to come. Then I received the email also from Martin Draven to that effect.
Okay, all right. Now, I guess from the document, there is nothing that indicates why it should not be open tender.
Exactly.
Yes. So when you read it, you must have wondered why he took a different view but didn't discuss that with you?
That is correct.
Yes, but you didn't ask him.
I did. There
You
is
did?
an email response to him.
The Kennedy will reach it when...
Thank you, Chair. Perhaps we can do that right away. Page
Yeah.
659.
Yeah.
Should I read it?
Is that the email that you sent in response to Mr. Turbis?
True.
Page 659?
Yes.
Is that the one?
Yes.
That is correct.
Okay.
And if I can just read out the relevant part, I've gone through the document. I realize that you've taken out my recommendation, and now the document has the name of the supplier specified. I don't mean to belabor the point, but I'm still of the opinion that should management approve this request, DLS must go out on tender or RFQ. What does that stand for?
Request for quotations.
Right. As you had done in relation to the 217 hulls contract.
This was under now the new policy that was in place, not under the previous dispensation.
Right.
Which,
And then to continue for the appointment of the single source for the scope of work. Once we've identified a supplier that meets DLS requirements through a competitive process, then we can appoint such a supplier for a maximum of 3 years as a single source. The specification, presumably, and evaluation criteria must be sent, etc. And then you raise another point. Furthermore, I think that it will only be fair to allow LMT to compete for this work. Firstly, we had a contract with them for trunnion FCM machining, which is part of the proposed scope of work in this request, which was later cancelled due to reasons unbeknown to me because it was before my time as the executive manager of supply chain. Secondly, when we suspended the order for the AV8 FCM, we wrote a letter to LMT where we stated that the intent at the time was to continue or finish off the execution of that particular order as part of the Hoefeyster FCM order. I'm not saying that the work must be given to LMT. All I'm saying is that LMT and other capable suppliers must be given a chance to prove themselves through a transparent, competitive, and fair RFQ or tender process. I don't think we should piggyback on the process that was followed for the platform hull. We should go out on a separate RFQ tender process where we invite all suppliers that we think are capable and then do such appointment. I will ask Michelle to schedule a meeting. So you reinforced your point raised earlier that it should be a tender process. You were not suggesting, as I understand it, that LMT should automatically get the business.
that is correct.
But you were envisaging still a tender process in which LMT could tender, other competitors could tender, and so could VR Laser.
That is correct.
Right.
A single source is not necessarily in conflict with an open tender process.
No,
You can go through an open tender process and end up with a single
That
source
is correct.
supplier. Okay.
So would the opposite arise in this situation? If there is a single supplier in the world for something that you require, you would have to go to that person and you would not have to follow a tender process.
That is correct, and we had a process that was stipulated in the policies and procedures where there's just one only supplier in the world, and we can prove that it's only one supplier in the world, which is usually the case in case of OEMs, original equipment manufacturer.
Right.
Is the terminology used in terms of National Treasury regulations the same as sole supplier or something?
Yeah, I think it's something to that effect. I haven't worked on procurement
Yeah, I think that's why I
for
was
many years.
asking whether
Yeah.
your concept of sole supplier here is in conflict with an open tender, because I think in terms of National Treasury regulations as well as supply chain management policies of many state-owned entities, there will be a provision which says if that is the only entity that can provide
The sole
that
supplier,
kind-
yeah.
yeah, and I think it's referred to, if I'm not mistaken,
It
sole
is.
supplier. But then it means you don't go open tender.
Correct.
You just go to that supplier, and your justification is that they are the only ones.
Correct, and you need
But-
evidence to support that.
Yes, but your sole supplier is not along those lines. Your sole supplier is one that you achieve after an open tender process.
So that's why I prefer to call it single source, after you have
Yes,
now.
okay,
Yeah.
now maybe it's the single supplier and sole supplier that.
Yeah, no, I do
Because
understand.
if it is a single supplier, it must be a sole supplier
Yep.
as well.
Yep.
So- Okay, so,
But,
yeah, but your single supplier concept does not exclude using open tender, whereas the sole supplier concept under the National Treasury regulations excludes open tender.
It would not make sense to follow an open
Yeah.
tender because it will just be one
Yeah, okay,
company
all
that
right.
can provide you with that.
It's just necessary to understand these things
No,
because
totally.
we don't deal with them every day, so one could end up getting confused.
Then we have the same definition that we're working on.
Yeah, okay.
It is complicated, Chair.
Yeah.
I believe the PFMA and the Treasury regulations and the SCM policy and so forth, as you rightly say with respect, refers to sole supply, but there it is defined in a particular way that there is
Yes.
only one supply effectively available in the marketplace.
Yes.
But here, can I just get you to confirm, here there were various manufacturers in the marketplace who could compete for this business. And if you awarded one of them the contract, they would then be, perhaps I can use the term single source as far as Denel is concerned, for the period of the contract.
That is my belief.
Right.
But
Now-
actually, I think, Mr. Kennedy, it's good you raised that point because what I said earlier may cause more confusion, I think. When you talk about a single supplier, it's not as if that supplier is the only supplier who can provide you whatever services or products
And-
that you want. It's just that for a particular period, you are committing yourself to obtaining those services or those products from that supplier.
In this context, yes.
Yeah, but would it not be the same thing? Isn't it possible that you would not need to actually say, to commit yourself like that? Because if you say, we want somebody who is going to supply us with X for the next 3 years, necessarily that means that's where you are going to get it. You can't go elsewhere.
Sorry,
If,
I
if
missed
you
that.
if you leave out the terminology of single supplier,
Yes,
you say we want somebody who is going to provide us with X products for the next 3 years. They compete and one wins. Automatically that one who has
Becomes a
won
single
is the
source.
only one who is going to give you.
technically it's the same,
So even if you don't use the single supplier terminology,
the terminology, yes.
yeah, okay. Mr. Kennedy.
Thank you, Chair. Now, Ms. Miller-Schleller, so your approach was, to sum up, we must go out to open tender. At that stage that you sent that memorandum for approval to Mr. Chibis, before he changed it to reflect VR laser, had you been told by anybody that you must actually do it on the basis that VR laser will be awarded the contract without a procurement process?
I can't recall specifically.
Okay, so he raises then in the email and the attachment which he had changed, he raised an approach which was no tender, no public procurement, it must go to VR laser. You responded page 659, we've just been through that. Did he come back to you in answer to these questions that you raised, or these opinions that you expressed that this was not appropriate?
I believe that we've got an email to that effect. You must just look for it, where I'm not sure if it was before this email or after this email. I must just look and confirm now with my statement. There was one email where he's saying that his view is that it's fine, we will proceed and take this to EXCO, but it will be to get strategic direction, not to approve VR laser. So my understanding was that VR laser now is out of the equation, and EXCO will be approving the strategic decision to do the single source work, for us to issue it out, that they're okay with it as a strategic direction, not to approve it.
So you understood his response to be that he was abandoning the idea that this should go to VR laser,
That is correct.
and that this would go to EXCO, and what would EXCO, what direction must it
They
give?
will approve, I think there's an email to that effect,
Yeah.
you'll find it. They will approve the principle of having this work being issued out as having a contract, a single source contract.
Oh, okay, all right.
That's the strategic decision.
Yeah, okay.
Do you know whether an agreement was eventually signed with VR laser for this particular single source supplier?
Yes, I believe it was in May. We've got the attachments here, we can refer to it, where I went to go and motivate procurement, I believe from LMT, for work that has to do with the scope that's included in here. And in that particular meeting, I was told that, I was asked first, why am I bringing motivation for LMT to get the work while we have a contract with VR laser, which I was not aware of. All of that is minuted in the, we've got the annexure. The minutes is the annexure.
Does it look like VR laser got appointed without your knowledge?
Yes, it was.
Yeah, okay. Yes, Mr. Kennedy.
If I thank you, if I can take you back to page 159.
Got it?
So just before Mr. Kennedy asks you further, so did Mr. Chibis ever advance any arguments to you as to why the open tender route should not be should not be used?
Not that I can remember.
Because you had made that point very emphatically to him.
Yeah.
But
No.
yeah,
He hadn't.
okay.
Thank you. Page 159, paragraph 5.8 in your statement, you say, no further response was received regarding my email of the 23rd March 2015. I was no longer updated as to the progress of the approval of the draft submission under discussion.
That is correct.
And then you go on to deal with what you've just told the chair, that you later found in a meeting where you tried to motivate for an award of some work to LMT, that in fact there was already a memorandum of agreement that had been concluded with VR laser that gave them the single source supplier status for that type of work.
That is correct.
Okay. Now, your affidavit goes on in some detail to say that the appointment of VR Laser as DLS's single source supplier raised a number of challenges from a supply chain management point of view because it was in conflict with the procurement policy. Now, if I can take you, please, in the annexures, to the document that you've attached to your statement at page 662.
Which is the policy. Okay, got it.
So you said as an aside, which is the policy?
Which is the policy.
Yes, that's really the question I wanted to raise. So this is the one that you refer to in your affidavit, effective from the 19th of November 2014. Was that the new policy that you referred to earlier?
Yes, it is the one.
And what's the bottom line of this policy as far as it was relevant for this contract that was awarded to VR Laser without a procurement process that you had recommended?
Sorry, what's the question again?
What was the relevance, what is the bottom line of what you were saying here in relation to VR Laser having been given this contract without open tender?
Okay, so essentially the document corroborates what I said in the email to say that we were actually supposed to follow a process to appoint VR Laser instead of just putting it in a document and motivating it.
So, and I'm taking you back a little bit. This contract that you found out had been given to VR Laser without your knowledge was still the same contract that you had been involved in, except that it was now, I see here in your paragraph 5.9, it was now for 10 years instead of 3 years that you had recommended.
Not only that, Chair, I was actually very angry at some point because in the submission that was taken to corporate office, there was reference to supply chain, that we supported the document, which is not true.
And who would have done that, do you know? Who would have made that misrepresentation about your department?
I have no idea whether the document was updated at DLS or at DCO. So in the meeting where I found out, I was told that the document, the new signed documents and the motivations will be sent to me after the meeting. And I believe that we have an email to that effect where the divisional legal executive sent me the documents with the new submission. So I'm not sure who did it.
So is the position that a submission that you had prepared, which did not reflect support for this, was amended to make it look like you supported this new thing?
That is correct.
Okay. Yes, Mr. Kennedy.
Thank you, Chair. Ms. Malashlela, there's another point relating to the policy that you highlight in your affidavit. If I can take you to page 669.
Found it?
Clause 6.10. Intergroup and group procurement contract 610.1 says under no circumstances shall products or services that can be procured from a group entity or division be procured from an external supplier or non-Denel company unless there is approval by the group supply chain executive based on sound business reasons. Now, you've mentioned previously that you had raised concern about LMT, partly because it had had a contract cancelled and you felt it was fair to at least allow it to participate in a tender. But you've also mentioned that LMT was majority owned by Denel itself.
That is correct.
Would LMT fall under the scope of what is referred to here as a group entity?
There were actually conflicting interpretation with regard to LMT, since it wasn't, I would use DV as the previous BAE as an example. So with BAE or DVS, it was clear that it was group entity, what we were referring to. But with LMT, sometimes it was treated as an outsider where it had to follow a process.
Now, you've referred in your affidavit to an EXCO meeting of DLS EXCO, where there was a discussion about the agreement that was in place with VR Laser, this particular agreement. And you've referred in your affidavit to the committee taking a decision that the agreement with VR Laser takes precedence. Can you tell the chair, please, what happened? What was in fact discussed? Were you present at that meeting?
I was. If I may digress a little bit. So following having received the documents that were signed, I felt a bit aggrieved and I didn't know which avenue to explore now, because it looked like my management was part of, how do I put this? My management was instrumental in that documents getting signed. So I spoke to the group CFO.
Your management being Mr. Chibas?
Yes, and
Yes.
Mr. Tiebas and Stefan Berger.
Yes.
So it would have been a futile exercise to try to speak to them about a document that's already signed. So I spoke to Mr. Fikile Mutlotlo. Sorry, I might be pronouncing the surname
Yes.
incorrectly.
The CFO at the time?
Yes, the group CFO at the time. That was around Q3 of the same year. And I highlighted what had happened and also that I was unhappy with what had happened. And I was hoping that he would be able to assist me to resolve this. Lo and behold, I think about a few weeks or a month after that, he was gone.
At when he was suspended?
That's when he was suspended.
But does this mean that at that time, you were able to put in front of you the submission that you sent and the submission that was amended by people you don't know?
That is correct.
And you could tell where the differences were?
That is correct, and I can still do that today.
Yes. Okay, and we have got that, those here.
I can just look through the
I
file
see.
because I got this file this morning, so I can
Okay, you
just
don't
look
have to
through the
look
file.
for it now. As long as we have got it, that's fine.
And now going back to the question that was asked, so after having explored that avenue and it didn't bear any fruit, I then decided to raise it in the committee where there's a lot of EXCO members. Perhaps they would take a different decision and raise the concern. Everything is in writing. Perhaps people will feel a bit afraid to go on with whatever was going on. And the decision was taken. We've got an attachment of the minutes, which was taken more than once, because I kept on repeating the same thing over and over again. And I also asked my team to start to ensure that we keep the recording. So not only did we type the minutes, but we also kept the recording of the minutes.
Electronic, mechanical recording.
Yes, it was
Yeah.
mechanical recording
Yeah.
of the minutes. So where it was, I raised the concern that I have a problem with this MOU, MOA. I think there's a lot of confusion with regard to what it is. That contravenes the policies and we have to continue applying it over and over again. Is it really also sustainable to keep on piling all this work on the same supplier for such amount of time?
Okay, all right. But the committee with whom you raised this didn't go along with your views?
No, they took a decision to say that the MOU supersedes the company policies, which is
okay.
also
I
documented in
I
the...
think I've seen that, yeah. Mr. Kennedy?
May I take the witness to what I think she's referring to? Page 672.
It's quite an interesting, strange thing, because agreements are supposed to be in line with policies
Absolutely.
to say the agreement supersedes the policies. The agreement supersedes the law. Yes, okay.
Now, Ms. Malashlela, won't you just please have a quick look at that? You'll see in the middle of the page, under the heading General 1.1, a concern was noted with regard to placement
I'm
of
sorry,
all-
I missed the page where we must go.
672. Chair.
672, okay, all right. Continue.
This records in the minutes that a concern was noted with regard to placement of orders. It relates to a deviation with the group SCM policy. Was that the concern that you had raised?
Yes.
Right. And then under the heading resolution, does this reflect what was resolved by EXCO?
No, that is correct.
The committee took a decision that the MOU takes precedence over the GSCE's condition and the group supply chain policy and the DLS supply chain procedure. The committee also stated that given the recent, presumably not recent,
Yeah.
but recent history with regard to price
price
presumably and turnaround time, VR was the preferred supplier with all opportunities. It was further stated that in terms of the MOU, VR laser prices must be market related and in line with the provisions of the MOA before an order can be placed on them. Due to this reason and previous experience with VR laser, the committee felt confident that the VR laser prices will be market related and reasonable. Sila Malashlela was tasked to draft a letter to the GSCE and explain the decision taken in this regard. Now, before we get to whether you sent a letter as instructed, did you agree with this? Were you persuaded by the reasons given for the resolution
No,
that was adopted?
I was not.
Were you a sole, lonely voice along this line in this meeting?
I can't remember anybody disagreeing, but I might have forgotten, but the decision was taken. We've got recording, the recordings
Yes.
should be at DLS, so we should be able to
Yeah.
find out what happened.
Okay. And what is GSC?
Group Supply Chain Executive,
Oh, okay. Who would have been?
Mr. Mlambo.
Mr. Mlambo. Okay. Had anything like this happened before in your experience?
No. Not
Where
that.
an agreement or memorandum of understanding is said to be above the policies of the company?
No,
Yeah.
not to my recollection that I saw it. I would have opposed it in any case, but anyway.
Yeah.
Now, may you turn please to page 677, 675 in fact.
675. Okay. Got it?
That's an email from you to EXCO, subject conflict between policy and the signed MOU. And then you say, find the attached for your final input. Now, is the document from 677 what you attached for their final input?
Yes, it is.
And why did you, and just identify the document at 677, please? Who prepared this and what is it?
I prepared it on instruction from EXCO as stated in the minutes on 672. So we were actually discussing an order with regard to T5, which is a product of DLS, which included fabrications. So that's why that subject has a reference to T5.
Now, did you actually sign this letter, 677, at 678? I see your name, but there's no signature there. Did you ever sign it?
I cannot recall. I might have signed it. I was asked to send this to Mr. Mlambo, but at the same time, I spoke to Mr. Mlambo about it.
Yes. Did Mr. Mlambo, in fact, sign it?
No, he did not sign it. I think it's this one.
Let's talk about first, if we may, is just the the important features of what you say here.
Okay.
Yeah, just I deal with that to say, these are the main points you say in the letter.
Okay. Can I read it quickly?
Yeah, if you can, not read the whole thing, just,
So essentially, I was saying that the MOU conflicts with the provisions of the policy that was in place in the company. And I was also stating that the committee had taken a decision to say that the MOU supersedes
yeah,
the company policies. And I was informing Mr. Mlambo as instructed by the committee.
okay, all right. Okay,
So as you pointed out earlier, Ms. Malashlela, there's a bit of confusion. Sometimes people are referring to the agreement as an MOU and sometimes as an MOA, but let's leave aside that terminology. What was being referred to here was that there had been an agreement concluded with VR Laser. It had been picked up that there was a breach of the group's policy and the division's policy, and then if you can look at the last paragraph, please, on page 677, you say, due to these contradicting positions, supply chain approached DLS Exco, supply chain being yourself, is that right?
Yes.
And so you approached Exco to make a decision as to whether to honor the MOA and place the order on VR Laser or to follow the supply chain policy and procure from intergroup, namely DVS or LMT, for this project. DVS is Denel Vehicle Systems.
Yes.
Is that another Denel division, like DLS was a division, DVS was?
That is correct.
Right. So you were saying either DVS or LMT, both of which were either wholly owned or partly owned by Denel, could have been given the project if there had been compliance with this provision of the supply chain policy.
That is correct.
Do I understand it correctly?
Yes.
Right. And then you say, given the time frame, urgency, and history, Exco has recommended that the work be done by VR Laser. And then you say, I request permission to implement the Exco decision in this regard.
That is correct.
Right.
in a way, did you want a written instruction to say you can go ahead?
Exactly.
Yeah, okay. To cover yourself.
Something like that.
Eh?
It got to that point, unfortunately.
Okay, all right. But you say Mr. Mlambo did not sign it?
He did not sign. I think
Okay.
there is a response from Mr. Mlambo somewhere in the documentation that we can refer to. I'm getting a bit fuzzy with these
Okay.
documents.
No, Mr. Kennedy will get us to it if it's important.
Thank you, Chair. Sorry, I was just...
Oh, no, she just confirmed that Mr. Mlambo did not sign this.
yes.
And, but she says somewhere in the bundle there is a response, is that correct? Or a letter?
There is a response. I think he scribbled at the back instead of signing.
Yeah, no, that's fine, but Mr. Kennedy will get to it when it's convenient.
Yes. Chair, may I just draw attention to an issue that is just apparent to me now, and that is the affidavit refers to a note rejecting approval by Mr. Mlambo as
Yes.
Annexure CM 52. You will see, unfortunately, and I don't have immediately an explanation for this, when you get to page 680, this
680.
annexure was not available at the time of bundling the exhibit.
Oh,
So I'm afraid I can't put it to the witness.
Yes,
But the next
okay.
witness will be Mr. Mlambo himself.
yes.
And he will give evidence that he in fact refused to approve this.
Yes, okay.
And if the document is available in his bundle, then we'll draw your attention to that.
No, that's fine. That must be the document because the witness also says he's
He
scribbled
scribbled
at the back.
Yes.
Yeah.
But I
Okay.
don't believe that there's any dispute between any of the people
Yeah.
whose names have been raised in relation to these proceedings or in the documents, that
Yes.
Mr. Mlambo was asked to approve the deviation retrospectively, and he
Yes.
refused.
Okay, all right.
Right, Ms. Malashlela, may we now turn to the next contract. We've already dealt this morning with the first contract awarded to VR Laser for 217 hulls. The second contract that we've just dealt with this afternoon was the single source supplier for various components in the
Correct?
same project, and that was awarded to VR Laser, where you had said it should be for 3 years and subject to a tender process, and instead what was decided was it was for 10 years and it was given to VR Laser.
Yep, I recommended that we follow due process.
I'm sorry, you recommended?
That we follow due process.
Yes. Can you just comment on the 10 years? Was that, did that happen frequently within Denel, to your knowledge, that
And-
a single source supply contract would be awarded ever to a party for 10 years?
Unless it was linked to a specific project that was running for 10 years with clear deliverables, I cannot remember any contract of such nature.
Whereas you were the one who came up with 3 years, you never got to know who came up with 10 years.
Correct.
Now we come to a third contract that you deal with in your affidavit. You deal with it at page 161, paragraph 6. And that's an award of a contract to VR Laser in 2016. Correct?
Correct.
The year after the contract that we've just dealt with, the second contract. And you refer to an order having previously been placed the previous year in 2015 on LMT for specific items. And LMT, there was a problem with meeting the deliverables, delivery schedule for that. Can you just tell the chair, please, very briefly, why was that relevant to the appointment of VR Laser in this third contract?
So the order had already been placed on LMT. DLS changed the spec, and LMT couldn't meet, I believe, the timelines, because this is based on the information that I got, the timelines and the pricing as well.
Now, just to be specific, to make it clear, the distinction between this contract and the other two, as your heading indicates, this was a contract in 2016 to supply cradles, FCM outer shields, and armor components.
Correct.
And you say that an order had been placed on LMT which it hadn't fulfilled properly within time. And then what happened in relation to VR Laser?
No, that's not what I'm saying. So Denel Land System had placed an order on LMT for the production of FCMs for AV8 project.
AV8 project, yes.
The order was suspended due to inability of LMT to meet the delivery schedule for the new configuration, not the one that...
I see.
Yeah,
So it wasn't the original one, it was the later configuration.
the change in spec after the order had been placed.
Yes. And then you make reference to a proposal by VR Laser to do what?
To do the same work?
The same work that had already been placed as an order on LMT.
Yes.
How did it come about that they submitted a proposal?
So how it worked, my team had managers. So on the day-to-day doing the day-to-day business, they would go out on quotations unless I need to get involved in it.
Had there been any process, had there been any decision to replace LMT under the previous order?
So there were a lot of discussions that were happening between LMT and management. It was my understanding at the time that following this issue where LMT couldn't meet our requirements, there was some discussion with the management of LMT, and Mr. Tieves came to me to ask me to draft a letter, which I'm sure you've seen, and there were emails, there are also emails, where I'm sending this email to say that the order will then be placed under, instead of totally cancelling the order on LMT, we're just going to move it to a different program. And this, Mr. Tievers asked me to do.
Now, what then happened, Ms. Malashlela?
So the jigs and fixtures were removed from LMT and were then delivered to VR Laser to proceed with the work.
And what concerns did you raise with your colleagues as to whether or not that was correct?
With regard to moving the order,
And placing it on VR laser?
at the time we had this MOU, which we were now being told that we need to follow. So under the MOU, if we are following the provisions of the MOU, we could place that order. And then at the same time, we could give the other one to LMT later.
Okay. Did EXCO deal with the matter?
Not that I can recall. Later on, we're talking about a different issue. If you go to 6.5,
Yes.
then we are now moving into DLS having communicated to LMT that it has the intention of placing the Hofeester order for the FCM on LMT. Sorry, I actually did slip my mind. I raised the concern at EXCO on the 7th of March 2016, and there are minutes to that effect. Apologies for that, Chair.
Is that what you refer to in 6.4?
Yes.
So you raised the concern with EXCO at this meeting that DLS was now placing the very same order on VR laser without going back to LMT.
Yes.
Right. And then there's reference to EXCO taking legal advice. Do you know whether that was taken?
Yes, it was done. If you look at 6.6, there is communication with the executive legal in her capacity in that position.
Yes. And you referred to her saying that LMT should be afforded a right of first refusal.
Yep.
To submit a proposal.
Yep.
On the trunnion machining contract.
Mm-hmm.
Yes. Then you refer to your raising concerns again at another EXCO meeting, 22nd of March. But what was the outcome of all of this? Was an agreement in fact concluded with VR Laser for this third lot of items?
We just need to refer to the minutes. So Mr. Becker, in his capacity, so this is part of the minutes, in his capacity as the CEO of DLS, advised that the memorandum of agreement, in this case we're calling it the memorandum of agreement, but I think everybody knows what we're referring to, was signed by the group's chief executive of Denel and should therefore supersede the supply chain policy of Denel SOC in instances where two documents are in conflict.
All right, thank you. And then if I can take you to page 686.
What's the page?
686, Chair.
Okay.
.686 appears to be a letter from Ms. Govender to yourself.
Correct?
On page 688, the second last paragraph.
Oh, which one? Sorry.
688,
688.
second last paragraph. In my view, LMT needs to be given an opportunity to at least quote on the FCMs as DLS was furnished with its costing, etc. Is that a reference to what you mentioned earlier, the right of first refusal?
Yes.
Right. And then the document at 689, that appears to be a letter from you.
So if you refer to the minutes, you will see that I was asked to draft cryptic notes. If we can just go to the exact minutes, then you will see it.
Are those the minutes at page 693?
I just need to confirm because it refers to cryptic notes that I was to make and send to the group CEO. But I must just get to the exact reference. But essentially, we can find the minutes and refer to it properly. There were minutes. So
Okay.
essentially, I was requested to write cryptic notes to Stefan, hence that email going to Stefan.
Okay, let's move on from why there were cryptic notes and so forth. The agreement was ultimately...
Oh, sorry, I found it, sorry.
Yes,
It is on page 693.
yes.
If you look at the last comment, on
The last bullet. Yes.
SCE to provide CEO with cryptic notes on the summary of developments around the issue, which is what I did in the email. But if you page through, you will see that I've actually also bolded it as part of the minutes. I've asked the guys to bold it so that everybody knows what they're doing. You will see the last, it's not the last, the second last bullet on the third column on page 2 on top. It says CM voiced concern and sought clarity from the committee on whether supply chain should comply with the policy or the single source agreement. So essentially reiterating the same points that I've been reiterating over and over again.
Okay. Thank you. There's one last issue which I would like to deal with before we close your evidence, Ms. Malashlela. Can I ask you please to turn to page 699?
Let me see.
Now, this appears to be a letter or an email sent by you on the 20th of April 2016, addressed to Stefan. Is that again Mr. Stefan Berger?
That is correct.
Now, I'd like just to remind you of the relevant parts of the letter. You say this: having signed the preferred supplier agreement with VR Laser, Denel having been in the media with regard to its strategic alliance with VR Laser, having read several media reports about allegations of state capture by the Gupta family, more concerns are raised about the viability of the partnership and the risks that Denel will be exposed to should Denel decide to continue its relationship with VR Laser. I'm struggling to turn a blind eye to this phenomenon. Just tell the Chair why you felt it appropriate to raise this with Mr. Berger rather than Mr. Terbis, your immediate superior, and why you felt it appropriate to express that you couldn't turn a blind eye to these issues.
In 2016, the structures had been changed a few times. In 2016, we must just confirm, I believe that that was the time I was reporting to Mr. Berger himself.
Right? And what...
Why did you feel
So
this way?
I think somewhere in the email, I'm not sure if it's this email, but we can just check. I'm referring to, yes, if you look at paragraph 3, I'm referring to the meeting that I had with the CEO of VR Laser,
Yes.
where he acknowledged the ties in passing.
Ties with the
Who was
Gupta...
the CEO of VR Laser?
It was Peter van der Merwe
Peter van der Merwe.
at the time. So before then, it was hearsay, seeing media articles and all of that, but for the first time I had heard it from somebody that it was just in front of me.
And your letter says that he acknowledged ties with the Gupta family and the then president's son,
Yes.
Duduzane Zuma.
Yes, in
You
passing.
say all through indirect shareholding,
Yes,
as alleged by the media.
yes.
Right. Now you jump to the third paragraph. If I can just remind you of what you said in the second paragraph. In addition to the media reports and the acknowledgement by Mr. van der Merwe that there were ties between VR Laser and the Gupta family and the then president's son, you also mentioned in the second paragraph that it was your humble opinion, as you put it, that DLS had failed to follow the correct process when appointing VR Laser as a preferred supplier for the supply of steel components and fabrications. Amongst other irregularities, there was no RFQ or tender issued for the award of the contract. In this regard, I believe the DLS should have approached the market to ensure good governance.
Correct.
Right.
Now, going back to the paragraph where you refer to the CEO of VR Laser, you were telling Mr. Berger here, something that Mr. Peter van der Merwe had said in your presence on the 19th of April 2016, as reflected here?
Yes,
Yeah, so it's something that he had said in your presence?
yes.
Yes, okay.
Now you then, if you would refer to the last paragraph on this page, what essentially were you asking Mr. Berger to do?
I was asking him to reconsider the agreements that we have with VR Laser and terminate them.
You gave credit to him for showing great leadership and having achieved a turnaround in the division from 300 million turnover to over 2 billion turnover in less than 5 years. So you complimented him for that, and you expressed the feeling that you had as a Denel employee, a proud Denel employee. But what you say at the end of this page, the second last line, with the rate that this controversy is unfolding, I'm not certain that this company will even survive long enough for my children to see it. We ought to be proud of what we have accomplished. Equally so, we should do whatever it takes to protect this great legacy. Those are very firm and strong words. Why did you express your opinion in terms such as these, Ms. Maleshlela?
And maybe, Mr. Kennedy, if you don't mind, we may need to take a few minutes if it's necessary, Ms. Maleshlela, but I would like you, in your own words, to read that whole paragraph into the record. I think it's a very important paragraph.
The last paragraph.
The last paragraph, but maybe you need a few minutes to drink water?
I think so.
Hmm?
Yes, please.
Yes, okay, right.
Thank you, Chief.
Let's take a few minutes, 5 minutes adjournment.
May we ask you, through your associate, may we indicate when the witness
Yes.
has composed herself?
Yeah, that's fine, yeah.
Thank you, Chief.
Okay, we adjourn. I've changed my mind, Ms. Malashela.
Okay.
Rather than read the last paragraph, I want you to read the whole.
The whole email?
Yeah.
Okay. Hi, Stefan. Having signed the preferred supplier agreement with VR Laser, Denel having been in the media with regards to its strategic alliance with VR Laser, having read several media reports about allegations of state capture by the Gupta family, more concerns are raised about the viability of the partnership and the risk that Denel will be exposed to should Denel decide to continue its relationship with VR Laser. I am struggling to turn a blind eye to this phenomenon. I would like to reiterate that it is my humble opinion that DLS failed to follow the correct process when appointing VR Laser as the preferred supplier for the supply of steel components and fabrications. Amongst other irregularities, there was no RFQ or tender issued for the award of this contract. In this regard, I believe that DLS should have approached the market to ensure good governance. I would also like to bring it to your attention that the current CEO of VR Laser has acknowledged their ties with the Gupta family and the president's son, in bracket, through indirect shareholding as alleged by the media in the meeting we had yesterday, the 19th April 2016 at 3 o'clock in the afternoon. In light of all these facts, I would like to request that DLS carefully reconsiders the relationship with VR Laser as a preferred/strategic supplier. Denel is a strategic asset of this country, and I'm proud to be associated with it. It gives me great pleasure to wake up each morning to serve this country. I have had the privilege of seeing you turn this division from a 3 million rand...
300 million.
A 300 million turnover. Let me just start. I have had the privilege of seeing you turn this division from 300 million turnover to over 2 billion turnover in less than 5 years. We are no doubt a great company. Furthermore, I have great confidence that under your great leadership, we will achieve even more greater success. However, with the rate that this controversy is unfolding, I am not certain that this company will ensure. However, with the rate that this controversy is unfolding, I am not certain that this company will even survive long enough for my children to see it. We ought to be proud of what we have accomplished. Equally so, we should do whatever it takes to protect this great legacy. Kind regards.
Thank you.
Thank you, Chair. How do you feel now, some years after you sent this letter, about what actually happened?
I think that's actually what brought me to tears, because it's actually what is happening right now.
Was your plea in this email not heeded by Mr. Becker?
He responded
others?
harshly. There is an email to that effect, which was also part of a report that was issued. I'm not sure if it formed part of the newspaper article that was...
Okay.
Chair, may I take the witness to
Yes.
the foot of page 697 and on to page 698?
Yeah, found it.
Is that the email that you're
That's
referring
the email,
to?
that's the response.
Now, that's an email from Stefan Berger himself, and he will be given the opportunity to give his evidence before this commission in due course. We have him lined up, Chair. May I just read some relevant parts, Ms. Malashela,
That's
so
fine.
that you can respond? Can you just confirm this is a response to the letter that you've just read out in full at the Chair's request?
20 April, yes it is.
He says, "Dear Celia, I must say I'm very surprised and disappointed in having to receive an email of this gravity whilst I'm abroad, and also given the fact that the appointment of VR was done a very long time ago. and in a time you were intimately involved in the process of the selection of VR Laser as our strategic supplier of complex fabricated components. Was this the first time that you had raised these concerns?
If you look at the minutes, there is evidence that I had been raising it.
Actually, isn't the position that earlier on we went through even emails where you pointed this out time and again?
Yes.
That proper procedures were not followed.
So directly, I raised it with Mr. Tievas when he was sending me the submission. But from late 20, I think it's 2015, yes, 2015, late 2015, I was raising it in the committee with regards to conflict, and Mr. Malambo was also responding to a lot of issues relating to this MOA.
So is the position that he might be right in saying he only had recently of your concern because you had raised it in communication with other people and not him? Or is the position that you had raised it with him, he was aware of your issues in this regard?
I had not raised it directly with him. I had
Yes.
raised it with Rhiannon when he was asking me to do the motivation.
Yes.
And I raised it in the EXCO meetings,
Yes. So
which we have minutes of in the package and we've read already.
would he have been part of ESCO?
He's part of EXCO. He's actually the chair of EXCO unless,
So he certainly knew you had raised those,
yeah.
at least at the EXCO meeting.
If the minutes are there, it was discussed in the
Yeah,
meetings.
but your recollection is that he was there at EXCO meetings where you raised it?
Yes,
Yes, okay.
as far as I can recall. And
Yeah.
the minutes are there, which
Yeah.
are circulated to him as well.
Yeah, okay. Mr. Kennedy?
Thank you. Can you comment on his remark that you had been intimately involved in the process of the selection of VR Laser, which appears to suggest this, that you were part of that process, you went along with it, and are now raising it for the first time a long time later, while he's traveling, Mr. Berger, is traveling overseas. In other words, you seem to be happy with it now. You haven't raised it before, you're raising it now. Any comment on that?
As you have already, sorry, what was, I'm losing my train of thought. What was the question again?
He seems to be suggesting that this is an afterthought by you,
Okay, yes.
because you were involved previously in the process of VR Laser, so why are you complaining about it now if you were part of that process?
I collected my thoughts. So as you know, I was not, at this stage, you've seen the document, I was not involved in the process of appointing VR Laser as this preferred supplier for fabricated components.
But is the position, as I understand it, the position is that you had a role to play in a process that ended up with VR Laser being appointed, but you were not involved in the appointment, actual decision to appoint, and you did not support that. Your involvement was earlier, and that's why you took the point that there should be an open tender.
Correct. I said outright in the beginning that
Yes,
due process should be followed.
yes. So the position is not that you had no involvement in the process. Where you had no involvement is in the decision to appoint. But in the process that preceded that, there was some involvement, and you took your position that there should be an open tender. You made it known, it was not supported, and without your knowledge, VR Laser was appointed.
Yes.
Yeah, okay.
So it also depends, I don't want to waste time, it also depends on how you interpret it. I was not involved in the appointment of VR Laser.
Yes, no, I think we are agreeing that,
Okay.
on that you were not involved in the appointment. but there is a stage
When the
at
process
which you were
started.
involved, and that stage allowed you the opportunity to say what process, in your view, should be followed.
Correct.
You articulated your views to those to whom you were supposed to articulate it. They did not follow your opinion, and without your knowledge, VR Laser was appointed.
Correct.
Yeah. Mr. Kennedy.
Thank you. Then he says at the foot of the page, 697, Mr. Burger says, I also question the fact that you want to reiterate that the correct processes were not followed. The first time I heard you say that was very recently in the passing, and was after the media was questioning the Gupta's involvement and painting a negative picture of Denel. So again, he seems to be making the point, you're raising this for the first time very late. You raised it in passing after there was media coverage, but that was a very recent comment by you, and you didn't raise it at the time of the actual procurement process. Anything to add to what you've said already?
I think I'm going to be repeating myself.
Okay.
Yes.
Yeah.
Yeah.
And-
So if it is true that he was present at the EXCO meetings, I don't know if it was meetings or meeting, where you raised your issues with this, then he can't be genuine in
Exactly.
saying he's hearing he only had recently.
That is my point exactly.
Yeah, that's your point.
Yeah.
Yeah. Obviously, if he was not present, that might change the picture, but your recollection is that he was present and he was chairing the
And the
EXCO.
minutes were circulated to him as well.
Yes, okay. Mr. Kennedy.
Thank you. The top of page 698. However, I do agree that it is not pleasant to hear the Denel name in a negative connotation, and I'm equally proud of the successes of DLS. That seems to be a reference to your statement in your letter that he was replying to, that you were proud to be an employee of DLS and Denel. But he then proceeds to say this, but I want to categorically state that I do not agree with your statement that proper processes were not followed. Surely we did not send out an RFP for the appointment of a strategic supplier. So he agrees that the company didn't go out as you'd recommended to go out in a competitive
Correct.
process. But then he says, but we did identify the most complex of complex fabricated systems and went out on open tender, and we did this twice. Do you know what open tenders he's referring to there? Right.
Yeah.
And he says, and this VR won by following the correct processes. Only thereafter VR was selected and motivated as a strategic supplier. The approval thereof at DCO was done by following due processes. Now, perhaps, Mr. Burger, you're not sure what he's meaning, but let's just assume for a moment that I'm right when I raise this as a possible suggestion that Mr. Burger may have been trying to raise. He may have been referring to the original contract before the single supplier contract. Single supplier contract, you said, has to go out on open tender. And he's confirmed in his letter you didn't go out, your company didn't go out on open tender then. Perhaps he's referring to the previous process in which there was an RFO, where LMT submitted proposals, so did VR Laser, so did the other company. If that suggestion that I'm putting to you is right, what do you have a comment on what he seems to be saying?
Part of my email that I had written to Rhiannon, I had clearly said that we cannot piggyback on previous processes.
Yeah.
So
So
that is not due process,
So your answer would be,
if that's what
In-
he's referring to.
your answer would be, at a factual level, with regard to this particular appointment that we are talking about, no open tender had been
Exactly.
been followed. And your view is, and was at the time, there was no justification for not following an open tender in regard to this particular point.
There was no justification in not following due process. Remember that?
Yes.
Yes.
But the due process would mean the open tender process.
In some cases, it would be a closed tender under the conditions that are stipulated in the policy.
Yes, but in this case, do you know which one would have applied?
It would have most probably been a closed tender
Closed tender,
because of the nature of the business.
which would be what? I'm asking for quotations.
It's the IP that's involved. We didn't get to that point, so now
Yeah.
I'm just. So
Okay.
there's a whole lot of things that you need to take into consideration. Then you motivate to Mr. Malambo. The policy called for motivation to Mr. Malambo.
So, on your understanding of the policies of the company at the time, it would be wrong to say what should have been followed would have been an open tender
Yes,
process. But what you say should have been followed is a closed tender process. Is that right? But
most
it was not.
yes, most likely because of the
Most
nature.
likely, yes. But not what was done.
Yes,
Okay, all right.
and if
On what was done, you say there was no due process.
there was no due process.
Yeah,
And
okay.
if I may, if Mr. Berger is referring to, if he's saying that open tender process was followed, we all know that open tender process was not followed for the previous processes. Hence, I am shrugging my shoulders. If he's talking about open tender, unless he's talking about a process which is an RFQ or an RFO, that is a different case altogether. But I had also clearly stated that you cannot piggyback on that.
Yes, yeah, okay.
Just clarify, if you would, please, what you mean by the piggyback. Don't piggyback on that.
So essentially, what it's also said here to say that we've gone out on a process to appoint the supplier for this and this and this and this. Because of that process that we followed, we now appoint the same supplier for additional work, which was not part of the original scope.
You can't rely on the previous.
Exactly.
Yeah, you can't have a situation where if you have had an open tender process in regard to the provision of ABC products to the company,
Then you add.
and that process has been completed, you can't later on, when you want a service provider which will give you or provide you with DEF products, say, I will take the
Same
one
one.
who succeeded in the other process or in the previous tender process because it won in that process.
Yep.
You can't say that.
Yep.
You have to embark upon a new process.
Yes.
That's what you say.
Yes, and furthermore, there are provisions with regard to extensions of contract, under what condition, under what circumstances you can extend contracts and the percentages.
Yeah.
So in this case, we're talking about a totally different scope. And yes, it was the armor plates and all, but it was for different vehicles and different, it was
Yeah.
for vehicles, it was for a whole lot of different
Yeah.
stuff as we've seen in the documentation.
Yes.
But on top of that, it was obvious that it was also going to exceed the threshold
Yeah.
that you are allowed to extend the contract for.
Okay.
Thank you. If I can continue then in this paragraph of Mr. Berger at page 698, the second paragraph there, the third line, just to overlap with what we raised earlier. But we did identify the most complex of complex fabricated systems and went out on open tender, and we did this twice. And this VR won by following the correct processes. Only thereafter VR was selected and motivated as a strategic supplier. Strategic supplier in the context of this letter appears to be a single source supplier, if you look at other parts of the letter. He then says the approval thereof, a DCO, that's group corporate level, is that right?
Yes.
Was done by following due processes. Do you agree with that assertion by him?
No. Like I said in my previous statement, I'll use the piggyback again. You cannot latch on to another process that was done.
Yes. And then he says to now say that processes were not followed just because we don't like the owners or what is written in the papers, presumably the newspapers, or that the CEO of VR is acknowledging certain connections with the Gupta family is also a concern to me. Now, may I just stop for a moment and ask your comment? You raised in your letter, I took you to that earlier, there were two main issues that you raised. The one was that you felt proper processes for procurement had not been followed.
Correct?
And secondly, you raised concerns about ties with the Gupta family and the consequent problem, potential problem for Denel and its reputation.
Correct.
Right. What he seems to be suggesting here is that you were using the Gupta family connections as a reason for only now, as he puts it, complaining that processes were not followed. He says to now say that processes were not followed just because we don't like the owners or which is what is written in the papers or what the CEO has acknowledged is a concern to you. What do you say about that concern?
So what I see here, he's alleging that I didn't like the owners of VR Laser. And it was, for me, it was not necessarily the people behind. It was, how do I put this? It was more how business was being done and the connections that were being alleged. Everybody knows about it, it was in the media. And it was not because it was in the media that I had a how do I'm trying to find.
It has to be that if you have the interests of the company at heart, you would be concerned if you find that
Absolutely.
the company is doing business with entities who would damage the reputation of the company.
Absolutely. But
Apart from processes,
yes,
if you find out that the type of entity that you have a contractual relationship with is not the type of entity that
things
you'd
were
like
not
to be
about
associated with,
Yeah.
obviously that must be a concern if you have the interests of the company at heart.
absolutely. What I wanted to highlight, I believe that did not like, or I would just use hate, is a strong word. I did not hate VR Laser, and I did not dislike VR Laser. It was what was happening that I had a problem with.
Ms. Malashlela, his next paragraph starts, and I'm not going to read the whole thing. He says, I'm convinced that the successes DLS recently had was amongst others also due to VR Laser's sterling performance as a strategic supplier. And here I'm just going to paraphrase, if I may, Chair. He refers to the Turret Hull contract in Malaysia involving BR going extremely well. He doesn't believe any other current supplier could have achieved this. He refers to the UN for a contract for the supply of Caspers that they required that when the contract was awarded to DLS, it was on condition VRU was used to fabricate because of their past experience. And also he refers to Patria in Finland, finding that VR was the most competent. So in other words, he's saying we did the right thing by appointing VR Laser because they're excellent at their job. Any reaction to that?
So as I just said previously, I did not hate or dislike VR Laser. It was the way of doing business that I had a problem with.
Then he concludes his letter by saying this, therefore, Celia, what I'm trying to say is that VR Laser is widely acknowledged as one of our very best suppliers. They are black-owned, and I believe that proper processes were followed in their selection. We cannot now cancel their contracts just because the papers paint a negative picture of their involvement with the Guptas, and the possible risks on our reputation in dealing with the VR is not something we are supposed to take a view on. What he seems to be suggesting, if I might just stop there, is that it's not appropriate for you as the head of procurement within the DLS division to be troubling yourself or troubling others in relation to reputational damage to Denel because of publicity attached to links with the Guptas, which could imply something improper. What do you say
That
about
is my understanding as well.
Yes. Was that criticism of you valid?
That I should not be concerning myself.
Yes.
As a manager in the company that I am proud of, and as a state-owned company, I ought to be concerned about such matters.
Then you,
Because there may be many reasons for that, but simply at a pure level, you were saying in your email to him how proud you were to be associated with Denel Land Systems and Denel. Obviously, if because of the company doing business with people who have a very bad reputation, that may impact on the reputation of the company you work for as well. You might not be so proud in the future to be associated with Denel if whenever Denel's name is mentioned, it's mentioned in the same sentences as an entity that has a bad reputation.
Absolutely, and it might actually go beyond that to the extent that our customers or business people that we did business with, or people meaning companies and different people that we dealt with around the world would have a problem doing business with us because of the reputation. They wouldn't want to be associated with us.
Yes, they might not want to deal with you. Actually, I had evidence last year. Banks they look at their client's reputation, and if you are associated with negative things and negativity, they don't want you as a client.
Absolutely.
So it's maybe Mr. Berger, when he comes here, will explain this, and maybe when he does, we will understand his point of view. But for now, I would have thought that everybody would want their company not to be impacted negatively in terms of their reputation because of who they do business with.
Absolutely.
thank you. Now, how did you feel? We'll get to your response in a moment. In fact, perhaps I must just finish off reading the letter from Mr. Berger. He says, after saying it's not something we are supposed to take a view on. This is something for DCO to consider, and I will take it up with them. You've indicated earlier that's the corporate office, that's at head office level of Denel, above the division.
Correct.
And so he said it's not for you to trouble yourself with this. He will raise it with DCO. And then he says, so Celia, may I please request that we discuss this matter when I'm back in the office on Monday. How did you feel, though, when you got this response from him?
Well, I was intimidated, to say the least, and I was wondering what he's going to say to me when he gets to the office.
Did you have a meeting with him?
We did, and the meeting, he just kept on going round and round. We didn't get to the solution where we get to, as you know today, the contracts were never terminated.
Did he give you any feedback to the effect that he had or had not raised it with DCO, with head office?
No.
Did you at any stage consider yourself raising your concerns at a level higher than Mr. Berger?
I did.
And did you take any steps in that regard?
Yes, I spoke to the group CFO, as I mentioned a bit earlier, and unfortunately he left the company after that. And I felt that I was running out of avenues, and I started saving money so that I would be able to leave the company and be self-sustainable and be able to pay my bills, even if I resigned without a job.
Is that how strongly you felt about these issues?
Yes.
Yes.
But I needed to be should I say, I'm looking for the word, it's right on top of my, I needed to ensure that I'm not taking a risky decision.
Just say that again.
I needed to ensure that I'm not taking too much risk when it comes to my personal finances.
Or in terms of living before you made proper
Before I have a
arrangements.
job, then I end up
Yeah.
in
Yeah, okay.
financial difficulties.
Okay.
Did you stay in supply chain at DLS for the rest of your time at Denel?
No. I left Denel in 2016.
Sorry, when did you leave Denel?
I left DLS in 2016.
DLS in 2016. Where did you go to?
I resigned without a contract at the time. And
Said you left at the end of 2016.
at the end of the same year after.
Yeah, same year,
Yes,
yeah.
same year. During the time when I was serving notice, I was then asked what happened. I didn't want to go into a lot of details, but essentially I was asked to come and work at DCO. And I worked with Mr. Malambo and the COO.
Okay, let me understand that at a certain stage towards the end of the year, or 2016, you decided you were going to leave Denel.
Yes,
But before you could leave, you were asked to work at Denel corporate office.
that is correct.
That request had nothing to do with your impending departure at the time?
No,
Or they
the
just,
request did not exist.
or they didn't know any about your
Yes.
plans? Okay, all right.
And if
Then what happened? How long did you work at DCO?
If I may just add on that, maybe this point is also important. So on the day of my farewell at DLS, as I was driving back to the office, Mr. Berger gave me a call that I should come to his office.
This is now on the last day at DLS.
On the last day.
Yeah, but as you were arriving in the morning?
We went to go and have a farewell breakfast
Oh, and then when you came back?
when I was now driving
Yeah,
back.
yeah.
So he asked me to have a meeting with him.
So you made a decision you were going to leave Denel,
Correct.
and you made that decision in circumstances where you had not obtained another employment.
Correct. I did not have any contract.
You did not have any contract.
Yes.
But you had reached a point where you said you could not continue
Exactly.
at Denel.
Exactly.
Yes.
So the intention at the time was that I would do volunteer work and I would talk to different people and see who's willing to.
Yeah,
Yeah.
okay, all right. So he asked you to come and see him.
He asked me to come and see him, and when I got to his office, he actually made me an offer to stay. And I believe, this is what I heard later on, that he had gone and asked HR. So I don't have evidence. I heard from different people, from somebody else, that he had gone and asked HR the salaries of the other EXCO members that were highly paid. And he used this as a benchmark as to how much he can offer me to stay. But now he was bidding against the corporate people now, which was.
Oh, yes.
Yes.
DCO
Yes.
wanted you at a certain salary as well.
Exactly. No. I left without an increase in my salary.
Oh, DCO was going to take you without an increase on your
I
salary?
did not get an increase.
Yes, okay.
Yes.
But he was offering you
More.
more.
Yes.
Yes, okay. And what did you do?
And I told him I will think about it, and there was nothing to think about. I just wanted to appease him. I went back and I told him I cannot take it, and I left. And following that, the environment, or rather the relationship, hasn't been. The greetings were less. We would meet at DCO. Sometimes it would be like, yeah, anyway.
To what extent did the tone and content of his response to you in terms of this email starting at 697 contribute to your decision to leave?
I felt powerless, and I believe that if you cannot no longer make a contribution in a company, then you shouldn't be there just for the sake of just sitting there doing what?
Yes.
Your role in a company is to make a meaningful contribution. And
Yes.
if the company does not serve you or provide you with that kind of environment anymore, then you should not be there.
Yes. And how long did you work at DCO?
I worked there roughly for about 7 months without being in any particular role, and around August I was asked to act in a position, and when I left I was acting in this position. I had no real position that I was appointed in.
So the notice that you had served, or you were serving at the time you went to have a farewell breakfast or whatever, that was a notice of resignation from DLS,
Which was revoked.
which was revoked
When
when you went to DCO.
yes, it was handled as a transfer.
And then you had to do a fresh resignation later on from DCO.
In 2017, I then left. Was it in
Oh,
2017? I've got the facts in here.
Okay, so earlier on you said you left.
Sorry, not in 2017. I started at DCO in 2017. I left Denel in 2019, sorry.
Or you left DLS towards the end of 2016
Yes,
and went to DCO.
yes,
And then you left DCO and Denel in its entirety in 2019.
that is correct.
Okay, all right. Okay, all right. Mr. Kennedy, I continued because I thought you were still, so you can continue or finish.
Thank you, Chair.
Or whichever.
Thank you
Yeah.
very much. I just have one further question of the witness, and it relates to a problem that arose earlier in her evidence because, and we apologize for this, the annexure was omitted.
Yes.
Ms. Malashlela, I'm just going to read out the paragraph, if I may, of your affidavit where this arose. Just for the chairperson's assistance, it's at page 161, paragraph 5.17 and 5.18. What you said is this: as is apparent from the draft letter, the group supply chain executive, and you mentioned that was Mr. Mlambo, was requested to grant his approval for the implementation of the DLS EXCO decision of 29 October 2015. That was the memorandum of agreement with VR Laser, and that took precedence over the procurement policy. And then you said Mr. Mlambo did not co-sign the letter, and you attach a copy of the letter, and you may recall, Chair, that is unfortunately in the copying process, that was not apparently available, and that you will find, Chair, at page 680. 680 of the same bundle, and we indicated that we would deal with that in evidence of Mr. Mlambo, but when the document became available, we would refer it to your attention. My learned colleagues have efficiently found the document in the very same bundle as an annexure to Mr. Mlambo's affidavit. I'm not going to take the witness to the affidavit, but if I may refer her to the relevant page and just ask her to confirm, is this the letter that she had in mind that Mr. Mlambo was not prepared to approve? Can I take you, please, ma'am, to page number 840? Do you have that?
Page 840.
840.
Oh, that's now beyond my section. In
That's
Dennis-
correct.
Yeah. Yes, that's the one.
This is the letter that we looked at earlier in draft form, I believe, which here is signed by you, and Am I correct in understanding it was then sent for approval by Mr. Mlambo? Are you able to say there appear to be two signatures further down the page? There's a note, a handwritten note that starts NB, and that's followed by a signature, and then further on, it appears to be a different handwriting and another signature from Mr. Nsepe. The first signature, do you recognize that?
Yes, I do.
Whose signature is that?
It looks like Mr. Mlambo's signature, just after the comments.
Right. So did he sign where you typed approval? Was he meant to sign there if he did approve it?
That was my understanding.
Yes. Did he sign it?
No,
And what his note says is a DVS and LMT must submit proof that they cannot meet the requirements prior to the contract being awarded to VR Laser.
that is correct.
Yeah. And
I'm sorry, Mr. Kennedy. I'm trying to follow what he is saying here. What you had said in the letter that he's not signing is that you had expressed your view that this should follow due process, but EXCO had decided that was not going to happen, and that they had asked you to draft a letter to him,
Correct.
which you had done.
Correct.
Now you expected him to sign approval, he doesn't.
Yes, I
So
thought,
what's the context of saying DVS and LMT must submit proof that they cannot meet the requirements? What is he talking about?
as you may recall earlier, we spoke about intergroup procurement. So
Yes.
LMT and DVS are in, yes.
Are they group entities?
So he was saying that they must then say that they cannot do the work before we can approach somebody else to do the same work.
Yes, but they are both group entities. I know that you said LMT,
LMT,
sometimes
yes.
regarded as group entity, sometimes not.
With that understanding, then we
Yes.
can say they are group entities.
Oh,
And I say
okay.
with regard to LMT, I put inverted
But
commas.
he was addressing a concern you had not raised here.
Yes.
It was just his own issue.
So conflict between policy and signed MOU. So policy said intergroup, you must go to intergroup companies.
Yes, okay.
So it was related to what I had raised in here, what I sought guidance on.
Oh,
Because we are referring now on paragraph 2, under no circumstances shall products or services that can be procured from group entity or division be procured from an external supplier or non-Denel company, unless there is an approval by the group supply chain executive based on sound reasons.
yes, so this would address the requirement that group entities must be given an opportunity to do the job.
Absolutely.
And only if they can't do it do you go outside.
Yes.
It would have addressed that issue,
If there
what
are
he's
sound
talking
reasons.
about.
Absolutely.
But it would not have addressed your due
Conflict.
process concerns.
No.
It would not have addressed
No.
that. Okay, all right.
I believe, but I'm sure Mr. Mlambo speaks to it, there was a point where he addressed the MOU itself. He addressed the MOU itself,
Okay,
but I'm sure he will speak to that in his testimony.
okay. Mr. Kennedy?
thank you. And just to provide clarity to a question that the chair raised earlier, you've confirmed LMT was a group entity. DVS stands for what?
Denel Vehicle Systems,
And that was also a group entity.
yes, which is the previous BAE.
Yes. Thank you, Chair. There are no further questions from us.
I know that, Mr. Kennedy, we have taken much longer with this witness than we thought.
We have.
Yeah, but I think that it was necessary and issues have been dealt with. We have done justice to the issues. There were important issues that evidence covered.
Thank
you. Thank you very much, Ms. Malahlela, for availing yourself. And from what I'm told, it looks like you may have had to shift your traveling arrangements in order to be able to give the Commission adequate time. Thank you very much. We appreciate that. Thank you for coming to give evidence. You are now excused. Thank you. Mr. Kennedy, I am available for us to use whatever time we can with the next witness, if that's fine with you.
Yes, may we proceed with the next
Yes,
witness?
yes,
He has
yes.
been waiting for some hours.
Yes,
So it would be useful if he could to at least start his evidence.
Yeah, at least we can use the hour, and then we can talk about whether he is available tomorrow morning to continue before we go to the next witness, or whatever arrangements.
Thank you,
Can be
Chair.
made, yeah.
May I then call to the witness stand Mr. Mandla Dennis Mlambo.
Yes, thank you. The files for the witness. I think nobody told Ms. Malahlela that they should remain here, the bundles.
I'm sorry, I didn't hear you, Chair.
I'm saying nobody seems to have told Ms. Malahlela that the bundles should remain here.
Oh, I'm sorry.
Yes, but she's still around.
Oh dear, I'm sorry
Yeah.
about that, Chair. The attorneys are also...
Please administer the oath of affirmation.
Please state your full names for the record.
Mandlenkosi Dennis Mlambo.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
Oh, help me God.
Okay, thank you. You may be seated.
Thank you, Chair. Perhaps through you, Chair, may I just ask the witness perhaps to remove his mask so that it'll be
Yes.
easier, more comfortable for him and more audible for us.
Yes. Thank
Killing
you.
me.
You may be seated.
Good afternoon, Mr. Mlambo.
And I
you for-
think just lower your mic a little bit. Yes, yes, yes. Are you comfortable?
Yes, I am.
Okay, all right.
Can I just suggest some guidance so that the Chair will be able to hear your voice clearly and the microphone will as well? I know normally when people ask you questions, you will look at the person who's asking the question. I'm going to ask you to act contrary to that for this afternoon. When you hear my questions, will you please direct your face towards the Chair and the microphone so that he and the mic pick up your evidence clearly? Please try and remember that. Thank you, Mr. Mlambo. I know it's
Yeah.
not all that comfortable, but it will help.
Well, I see that he's settling himself to look that side.
Indeed.
But let's see, he'll manage. It's important that I hear what you say, Mr. Mlambo. You understand?
Yes.
Or it might be the
I
chair.
do.
It looks like you are not very comfortable in that chair. You will manage.
Yeah, I will manage.
Yes,
There's not
okay,
much
all right.
I can do.
Okay. So when you give answers, try and look this side.
Okay,
Okay.
great.
Thank you. Mr. Mlambo, is it correct that you have consulted with us as the legal team for the commission dealing with Denel,
Yes, I have indeed.
and also with the investigators, and you have produced an affidavit? Is that correct?
Yes, that is correct.
May I ask you, in the file in front of you, do you have the document that bears your name? If I can ask you, please, to look at page numbers that are made on the top left of each page.
And just for the record, Mr. Kennedy, you confirm that for this witness too, we are using the same bundle that we are using for the previous
That's correct, sir.
witness, which is Denel bundle 01.
01, that's
Yes.
correct.
Okay.
And it appears, Chair, as Exhibit W11. I will ask to have that admitted once I've
Yeah.
had him confirm that it's his signature, etc. Mr. Mlambo, do you have page 704?
So,
Mr. Mlambo, won't you please just look at the page number on the top and see if
The
you've got
black
page
numbers.
704,
yes,
right? And is that the first page of what is referred to as a statement bearing your name, Mandla Dennis Mlambo?
yes, that is correct.
Is this the affidavit that you signed as requested by the Commission's investigators?
Yes, it is
Thank you.
correct.
Can I ask you please now to turn to the end of that affidavit at page 733? Do you have that?
Yes. I
Is
do.
that your signature that appears there above the signature of the Commissioner of Oaths?
Yes, it is indeed.
Do you confirm, Mr. Mlambo, that this is your affidavit and that its contents are true and correct?
Yes, I do.
Thank you. Chair, may we then formally ask for the admission of this exhibit, that's Exhibit W11 in Denel Bundle 01, as an exhibit of this commission?
Thank you. The statement or affidavit by Mr. Mandla Dennis Mlambo, starting at page 704, is admitted as Exhibit W11. Is that right?
W11, that's correct, Chair.
Yeah, okay.
Thank you, Chair. Mr. Mlambo, I'm going to take you through some parts of your affidavit and the annexures that require particular focus. Now, you were previously employed by Denel, is that correct?
Yes, that is correct.
When did you start there?
In 2004.
If I can take you to page 706. You've referred to your various qualifications, which include a Bachelor of Commerce degree from UNISA
Yes,
and various diplomas and other qualifications, correct?
that's correct.
And now, are you still working for Denel?
No, I'm not. I'm actually in the consulting business now.
Right. When did you leave Denel?
I left Denel in June 2019.
2019.
That's
And-
correct.
And what position did you hold at that stage, that when you left?
When I left, I was still group supply chain executive.
And when did you take up that position?
It was in 2012.
Now, if I can take you to your paragraph 2.5 on page 706, you make reference to your role previously as executive manager for supply chain, and then you make reference to developing and implementing various systems. Did those systems relate to procurement in particular?
No, they actually relate to business systems and processes.
As a group executive supply chain management, were the people who would report to you the people who were in different divisions or subsidiaries of Denel, but those who were supply chain management positions in supply chain like managers?
Yes, it was essentially the supply chain heads at the various divisions
Yes.
within Denel.
So in the context of the evidence of Ms. Malashela, would that have been Mr. Tubers to you who would have reported to you?
So there was actually a dotted line. The supply chain divisional heads actually reported either to the CEO or the COO or the CFO at the division, and there was a dotted line to the
to
group.
you? Okay,
That is to my position.
okay, all right.
So your position was that of group supply chain executive for the group as a whole? Is that
Yes.
correct? And then the group comprised various entities, head office and a whole lot of divisions?
That's correct.
And was DLS one of those divisions?
Yes, it was.
And DVS another?
And yes, DVS as well.
And did each of those have their own procurement section as well?
Yes, each of the divisions had a supply chain function. Some people prefer to call that a procurement function.
And would you liaise with those people?
Yes, we had regular meetings, and they were also at liberty to consult with me if they had challenges.
Right. Now, so did you have contact with Ms. Malashlela, who gave evidence before you today?
Yes, I did, probably more so than with other divisions. I suppose that would have been because of the Hoofeister contract.
Right. Now let's get immediately to that Hoofeister contract.
Mm-hmm.
And you deal first with the Hoofeister contract. It was specifically for the production of 217 armored hulls. Is that right?
Yes, that is correct.
And you deal with that in your affidavit from in paragraph 3 from the top of page 708.
Mm-hmm.
Now you refer first to the procurement policy. Were you involved in the formulation of that procurement policy once you were appointed as group executive?
No, the 2008 version, I was not involved in the drafting thereof and giving inputs to that. I actually inherited it.
You inherited that.
Yeah, the 2008
Right.
version.
Was that then revised?
Yes, it was revised
When was that?
in 2014. Well, the process actually started in 2013, but it was ultimately approved in 2014 in November,
Right.
because it had to be ultimately approved by the Denel board.
Okay. Can I take you, please, in this bundle to page 742? You have that?
Yes.
Just tell the chair, please, what this document is.
This is a delegation of authority that was issued in November 2012. That was for the whole group of Denel.
So would that have to be followed and applied in a division such as DLS and DVS?
Oh, yes, across the group, with the proviso that divisions were actually given the right to customize so long as they did not deviate from ensuring that there was alignment with the group delegation of authority.
Right. Now, may I ask you please to refer to page 757. I apologize, Chair. Now, may I draw your attention to paragraph 5.1? Just explain to the Chair very briefly what this provides, 5.1.
5.1 essentially stipulates
I'm sorry, 5.1 at what page?
Page 757, Chair.
757. Yes, okay.
this deals with the normal procurement of products and services. And of course, it also stipulates the approval levels that are associated with this delegation of authority, depending on the value of the transaction. Then there is a certain executive or individual that's authorized to approve. If you look at the first one, anything below 50 million and equal to 50 million would have had to be approved. A transaction would have had to be approved by the divisional CEO. And then between 50 million and 200 million, the group CEO, and anything above 200 million had to be approved by the board. But in all instances, I had to be consulted to satisfy myself that the processes followed were consistent with the policy and the relevant legislation.
And where do we find reference to that in this table?
I'm sorry, Mr. Kennedy.
It's in the remarks, the last column.
Right.
1 second, I'm sorry, Mr. Kennedy. I just want to connect this with what we were dealing with earlier.
Yeah.
You remember when we were dealing with Ms. Malahlela, that reduced price of the...
I'm sorry, that?
That reduced price of VR laser. You know, they reduced the price, and we were wondering whether the reduction of the price meant that the deal could be approved by the GCE, or by the board. It appears now that we have gone back to these delegations that if it was 200, more than 200, it should have gone to the board. I'm under the impression that the reduced price was still over 200 million. I may be mistaken. I thought it was 200 and something million. The one that VR laser used after reducing it. It was. Yes. Okay. No, that's fine. It's just that I remembered that we were not sure when Ms. Malahlela was giving evidence, and I was interested in seeing whether it was an amount that should have gone to the board or to the group CEO. Okay, all right, continue.
Mr. Mlambo, so you've dealt with who has to approve it. In the case of a contract worth over 200 million, only the board could approve that, correct?
Yes, that is correct.
And then you were just starting to take the chair to the final column of this table, and you said that in all three categories, your approval, you're the group supply chain manager referred to in that last column, is that right?
That's right.
And
I'm sorry, Is group supply chain manager the same as group supply chain executive or something?
Yes, it is in the
Oh, I
sense
thought
that-
manager would be lower, executive would be higher.
Yeah, and unfortunately, I didn't proofread this delegation of authority before it was issued.
Yeah, okay, all right.
You didn't demote yourself, Mr. Mlambo.
No, I wasn't party to the drafting
Right.
of this one. Yeah.
But it seems that from the item that starts with less than or equal to 50 million, in the last column we see group supply chain manager prior consultation on procurement above 20 million. So am I right in understanding that if it's less than 20 million, the divisional procurement people don't need to consult you prior to giving, to recommending for approval by their CEO, but if it's between 20 million and 50 million, they do.
Yes, anything from 20 million had to go through my office.
Right. And then the same point is in the next item in that last column. And then for contracts above 200 million, a report outlining the process followed to invite and shortlisted suppliers and evaluation and scores of the shortlisted suppliers and recommendations of the tender committee must also be tabled to the board for approval.
Yeah, that is correct.
And so for those contracts,
I'm sorry again, Mr. Kennedy. I just want to make sure that I understand what we talked about earlier about the title. Is the position that where it says group supply chain manager, it is correct, or is the position that there is something wrong, it should have said executive?
It should have said executive, but
Yes.
Yeah, there
so,
was-
So the correct position is that the person who was supposed to be referred to here is group supply chain executive. It was a mistake that it was said manager.
yeah, because I was the only one in the group in that
Yes.
position.
Okay, all right. So if I make a note to say executive, it's actually correct.
Yes, it is correct.
Okay. Thank you, Mr.
thank you, Chair. And just to
Kennedy.
complete that issue, Mr. Mlamba, would divisional procurement and other officials, such as Ms. Malashlela, have understood this delegation when they read it? If they saw group supply chain manager, would you expect them to understand that to mean you as group supply chain executive?
Yes, because this was actually at group level, and there couldn't be any other group supply chain executive or manager except me at the time.
In terms of the titles, at group level, would you have anybody that could be referred to as a manager?
Yes.
You could have.
Yeah, you could still find that.
Yes, but certainly within group supply chain, at group level, there was no person who was manager. There was just the executive, which was you.
Well, there was a group supply chain support
Manager.
manager that was reporting to me.
Oh, okay.
Yeah.
So this group supply chain manager could actually cause confusion.
Yes,
Because
yeah.
someone would not know whether they left out supply to say group supply chain supply manager, or whether they meant group supply chain executive.
Yeah, it could
It could cause,
definitely.
yes,
I
yeah.
think people were just not meticulous enough when
Yes.
drafting an important document like this. one.
Yes, okay, all right. Okay, Mr. Kennedy.
Thank you, Chair. Now, your affidavit then refers to a submission that you received from the DLX Exco. I just want to get the page for you. Might just have a moment, Chair. in the same bundle, if you can turn please to page 772.
772.
Yes.
Yes, I found that.
Now, what is that document? It's headed Group Chief Executive Officer's Supply Chain Submissions. It's dated the 1st of July 2014, and it's a note addressed to EXCO. Would that be Group EXCO or DLS EXCO?
This was actually from DLS, and it was a submission for approval of VR laser for the supply of the 217 platform house. Although here it refers to 183 platform house.
Yes, the Commission has already heard evidence of a previous witness. If I can just take you to page 774, there's an explanation for how the 217 was reduced to 183. And was it sent to you simply to give your views or to approve it or reject it?
Well, this one, if I look at the signatories on the last page, it actually bypassed my office, and what should have happened before it went to the group CEO, it should have gone through my office so I could actually verify whether the process that was followed was clean and compliant with our policy and relevant pieces of legislation.
I'm sorry, on what page are you looking at what you are saying? You say it had bypassed your office. I assume that's because you see somebody's signature or what?
Well, this one isn't signed. I think there is one that has got my name, but that's the one that we'll probably talk about later,
Yes.
that I rejected.
So, but what makes you say it had bypassed your office? What is it that you see that makes you say
Yeah,
that?
the group's CEO could not possibly have known that the process was compliant. And for a big transaction like this one, it was a huge risk for him to simply append his signature, because that entire transaction could be deemed irregular.
Yes, but I would understand if you say that when we see where he has already signed before without you signing. So I'm wondering whether there's a page like that where you say, I can see it bypassed me because on this page there is Group CEO's signature, but there isn't my signature.
Yeah, okay, this one is not signed.
But you say there is another one that is signed,
Yes,
which is basically the same thing.
yes, exactly
Okay,
the
all
same
right.
thing. Yes, Chair.
Okay, so that's why you say it bypassed your office. Okay, all right. Mr. Kennedy.
Thank you. Now, Mr. Mlambo, your affidavit indicates that that you had difficulties with this proposed transaction, and you raised some of the reasons in your affidavit, and you refer to a number of emails that we'll come to in a moment. May I take you, yes, let me take you immediately to page 787.
Did you say 777?
787. Chair.
787.
In fact, may I start at 788? That's an email from Rienan. Is that Mr. Rienan Terbus
Yes.
at the top? In fact, let's start in the middle. That seems to be the first. email. It comes from you on the 2nd of September to Celia and Renan. Is that Celia Malashlela and Renan Tubers?
Yeah, that is correct.
And then you're referring to LMT having a valid triple BEE certificate. I'm baffled as to why it was not submitted as per your claim at this evening's meeting. I will request details from Stefan Nell about the pricing and proof of shareholding of VR Laser as issued. So there are two issues that you raise here in this brief email, and that is LMT, whether it has a valid triple BEE certificate, and then the second issue is the shareholding of VR Laser. And that seems to have been raised in a meeting that you held with your colleagues from DLS. Was there such a meeting?
Yes, there was a meeting.
And what was the purpose?
The purpose was actually to convince me to approve this transaction, to award the contract for the 183 platform hulls to VR Laser. And after having looked at the entire submission, the scoring, the way the entire process was handled, I was actually not just angry, but I felt that this is the process that is being manipulated in order to favor VR Laser. The two critical things that I was actually angry over. The first one was that this should not have actually even gone out to external parties or companies to quote, because we had acquired LMT in particular to actually design and manufacture the same products so that we could meet our contractual obligations on the Woolfeister contract. So it baffled me. And the other issue is that Mr. Berger, because I was actually sitting on the board of DLS at the time, he was actually at pains to convince the DLS board about the importance, the strategic importance of LMT. And he pointed out that if we didn't save LMT because it was going through some financial difficulties, and there were also some governance lapses as well, which we could address as a group. He pointed out that we would not be in a position to execute the Woolfeister contract without LMT. So this really shocked me, that the same person now was actually punting the importance of VR Laser to actually be a strategic supplier, replacing a company that is 51% owned by Denel.
So in other words, the job that VR Laser was being asked to do, was going to be asked to do if all of this was approved, was a job that could be done by a company that is 51% owned by Denel.
Yeah, that's correct.
That was one of your points.
That's correct, Chair.
Yeah, okay.
Mr. Mlambo, can I take you, there are a whole number of emails, and I'm not going to take you through them all, but I'd just like to take you now to the one at page 787. In fact, top of page 788, Mr. Tubus Renan responds to you, to your earlier email that we've just looked at, and then you reply to him, it seems, on the 3rd of September on page 787. And you say the following: Hi, Renan, thanks for the prompt response. As I did not have an opportunity to do a thorough study of all the tender submissions, I cannot categorically claim that the process was sufficiently objective and the confidence level is high enough to place it beyond reproach. Nonetheless, the following are key issues that merit a serious review of the adjudication process and outcome. 1. The capability assessment of the three tenderers. Although LMT is the only one of the three tenderers that has manufactured the same hulls under contract from Patria, it obtained the lowest score. DCD has never manufactured the same hulls, and yet it obtained a higher score. The score the adjudication team came up with is based on the manufacture of a different product. VR Laser will be manufacturing this type of hull for the first time, and yet it has the highest score. Was that concern you raised, was it raised as part of your duties as group supply chain executive?
Yes, yes, Chair, it's true.
Then you raise in paragraph 2 the price difference between the VR Laser and LMT offers being almost 100 million. In my investigation, I was informed by Stefan that the LMT quote was based on factual figures, since LMT has manufactured the hull before. If Stefan is right, it would not make business sense to pay so much more. Since LMT is a sister company, I believe someone at DLS should have demanded the supporting evidence before assuming that LMT underquoted. I believe this anomaly wants further investigation and validation. Now, who had referred to LMT as having underquoted?
Well, this is captured in some of the emails that are here, and it was also raised during the meeting that we had that evening, or
Then
the
you-
evening before.
In the meeting?
Yes.
Right, and then you deal with triple BEE credentials, which were also referred to in the emails you've mentioned. Paragraph 3, LMT was given a 0 score on transformation due to its expired certificate. The two elements of transformation, namely ownership and EE, employment equity, could have been assessed without a valid triple BEE certificate. Such data should be readily available from the HR department. Would HR department be the HR department of Denel Group head office?
LMT HR department.
LMT HR department,
Yes.
and LMT, as you described it, was a sister company.
That's right.
In fact, the commission's heard evidence that it was 51% owned by Denel.
That is correct, Chair.
So you refer to that being readily available from the HR, and then you continue, triple BEE certificates, unless accompanied by a detailed report, do not give enough detail to be able to score the two elements accurately. If the transformation aspects of LMT were considered in the evaluation, it could have been rated number 1. So it could have gone up if it had been given some triple BEE points. Is that your point here?
Yeah, that's why, that is correct, Chair. That's why I suspected that there was something amiss here. It was just a deliberate action on the part of DLS to simply disregard the triple BE certificate of LMT.
Yes.
Well, how would LMT's triple BE profile or points have been assessed in the absence of a valid BE certificate? How does that happen? How does it work?
Well, in our evaluation, the focus was on ownership. And ownership had actually improved by virtue of the fact that it was majority owned by a state-owned company. That is an added benefit. That would increase its score. Prior to us acquiring LMT, it was a triple BEE level 4 company. So it was definitely going to be better than triple BEE 4, level 4.
Well,
And then we would also look at the employee profile, which is the employment equity a breakdown of the organization.
well, if a valid BEE or triple BE certificate is a requirement, what is the effect if a company doesn't have a valid triple BE certificate in terms of scoring?
Well, if the company is not in the process of being verified, then you would score that company as 0. But if a company has already communicated that they are in the process of being verified for triple BEE, as a potential client, you are actually expected to give that company an opportunity to complete that verification process, provided it's not going to be a prolonged process. Normally, it's something that's done within a week.
But isn't the position when you do these things in terms of processes that the closing date that is given, where I'm now going to talk generally, that closing date means each bidder, where you are talking about bidders, is supposed to ensure that its bid is in and it satisfies all the requirements that it is supposed to satisfy. Therefore, if one of the requirements is file your a valid BE certificate, and you don't file it, and by the closing date, that means you don't meet those requirements. Unless you move as a company, you extend the closing date for everybody, I would imagine.
Yeah, that's correct, Chair. That's what typically happens. And the standard practice is that you don't start with the evaluation until such time that if you've given a company 5 days to submit that triple BE certificate or a tax clearance certificate for that matter, then you only start after the company has failed to submit that on time with your evaluation, and that company would be given a 0 score for that.
But my point is this: isn't the effect of a closing date that you want to see those who comply with the requirements by the closing date and those who don't comply, and they are all going to be judged according to whether, as at the closing time, they complied or not? In other words, if I put in my bid by 4 o'clock today, and today is the closing date, 4 o'clock, and I've put in my tax certificate, and you have put in your bid, but you left out the tax certificate, you don't comply with the tax certificate requirement, and therefore you should be disqualified.
Yeah,
Isn't that how it works? Because you are all given the same amount of time to comply.
yes.
From the time the invitation is issued, or the request for proposals, whatever, from that date to the closing date, you all have the same amount of time to comply. Now, I comply. I make sure that I do my job, my homework timelessly. I'm able by 4 o'clock to put in my bid that complies with everything. You don't take this whole process seriously. You do other things when you are supposed to do your homework and put your bid together. And at the last minute, you run around. By 4 o'clock, there is still something that you haven't put in. Therefore, you put in a bid that doesn't meet all the requirements. You should be disqualified, and I should go in, isn't it?
Well, National Treasury has actually incorporated this into an instruction note that if a company claims that it's in the process of being verified for its triple BE status, it has to be given an opportunity. If it's in the process of rectifying its tax issues with SARS, it should be given an opportunity. And by the time you actually do your evaluation, if you've given them ample time, which is reasonable, and they haven't complied, then you've got the right to disqualify them.
So are you saying National Treasury has issued an instruction that says if by closing date a company says they are in the process of obtaining a verification for BE, or they are in the process of obtaining a tax clearance certificate, you should give them an opportunity after the closing date?
Yeah, but the proviso is that you shall not, for instance, contract a company that is not tax compliant. That now will be the time when you in the process of contracting. So if the company doesn't have or has not sorted out its tax issues with SARS, then you cannot actually contract that company.
No, I understand that
But
part.
with triple PE, if you've given them an opportunity and they haven't actually presented the triple PE certificate as per the given time, then you can give them a 0.
Yes,
There's
but
some leniency.
Yeah, but are you saying National Treasury has issued an instruction that says if a company has failed by the closing date to include its BE certificate or tax clearance certificate and says to you they are in the process of getting that, you should allow them time after the closing date to bring that in? Is that what you are saying?
Yes, but that doesn't apply to other aspects, like
Yes,
the
only
technical
those two.
requirements. Those are non-negotiable.
Yes, but these two,
Yeah,
there is room,
these you,
a
you
period
can
of grace can
accommodate.
be given to them. But that's because of a special instruction from National Treasury, is that right?
Yeah, because an opportunity could actually arise at a time when you are in the middle of a triple P verification process. And you should not be penalized because you're going through that process. It doesn't take long to actually
Well-
get your triple PE
Well,
certificate.
Mr. Mlambo, if it's official, it's part of policy or it's part of the regulations that can be done, that's fine, you know. But if you ask me, there is nothing wrong if you say, well, you have a month or 3 months, all of you, to meet the requirements. If you meet the requirements, you'll be in. If you don't meet the requirements, you'll be out. But next time we issue another one, you might be ready and then you will be in. But for now, you are in if you meet the requirements, you are out if you don't meet the requirements. But if there is a special statutory or regulatory provision or policy that says, in regard to these specific requirements, there will be some period of grace, but not others. I can understand that because maybe the idea is that, they don't want to be too harsh in regard to those particular ones.
Yes,
Yeah, okay, no, that's right.
thanks, Chair. Can I have some more,
Mr.
please?
Kennedy?
Thank you, Chair. If we can return to the emails that we were looking at, we've looked at the one at 787. Then, as I understand it, the email on page 786 is a response to you from Stefan Burger.
Yes, yeah, that's correct.
And then you, and I'm not going to go through it, he raises various points and arguments as to why you shouldn't be concerned about certain things. And you reply to him. I'd like to take you to page 785. That's your email of the 4th of September. And that's addressed to Stefan, where you were also copying in Celia Malashlela, Fikile Mshlontlo. Just remind us, please, who Mr. Mshlontlo was.
He was the group CFO.
Right.
Jan Wessels was the group COO, and Rhiannon Diebes was DLS's COO, and Riaz Saluji was the group CEO.
Yes. Now, if you compare that list that you've just read out with the list of people who were copied in the earlier email correspondence from you, between you and initially Mr. Terbis, and then it seemed to escalate to Stefan Burger, this seems to be the first time that you're copying in Rio Salugi, the group chief executive. Why did you copy Mr. Salugi in on this?
I realized that the issue was actually far from being resolved, and it was serious enough to warrant his attention as the group CEO.
Right. Now, if I may refer you to the body of your email, addressed primarily to Mr. Burger, you say, we are clearly not aligned in terms of the analysis of the data and information that I saw for the first time on Tuesday at the meeting I had with Rhiannon and Cedar. Was that the same meeting you mentioned earlier?
That is correct, Chair.
I certainly think we should not exchange any more emails on the issue in question, as the resolution may be easier to find around a table. However, the following issues have definitely not been addressed by your response. And here you raise a number of issues in paragraph 1. You refer again to the huge price differential in the offers made by both LMT and VR Laser. Now, you referred earlier to LMT being 100 million, approximately 100 million rand cheaper than VR Laser. And then you refer to information you had from Stefan Nel from LMT, talking about the fact that they'd produced the hull earlier and that's why their lower prices were reliable. And VR Laser's quote, on the other hand, was not based on past performance. So did you feel that the price differential that you'd referred earlier in an earlier email was not properly resolved?
Yes, and it just didn't make sense why people would be so anxious to pay 100 million rand more, which would actually erode the bottom line of DLS. It just was preposterous to me.
Then you deal in the second paragraph, number 2, with the conflict of interest. Just explain to the chair, please, what was your concern about the conflict of interest issue?
I was actually here referring to the submission in terms of the ownership and the adjudication team, that it actually accepted the fact that VR Laser was 100% black-owned company, and yet they did not interrogate the fact that the individuals were not specified, but it was just companies. And the document that was also submitted that was supposedly a list of the directors, it wasn't a valid CIPC document. In my view, it was a fake document. And the people that had actually submitted the conflict of interest declarations were not really the entire team of directors of VR Laser. It was the COO of VR Laser that had submitted, and I think Mr. Aurora as well. But the other people that were actually critical, people like Salim Issa, had not submitted any declaration of interest.
Were you, at this stage that you sent this email, were you aware that Mr. Salim Issa in fact had an interest?
I think it was probably shortly after getting a response from Mr. Aurora, because I followed that up to verify exactly who are the individual shareholders of VR Laser, because in terms of the documentation that I had seen that was evaluated by the evaluation team at DLS, there was not a single name. It was just Gasol and Crenshaw Investments. And I had to prod or push Mr. Aurora to disclose that 74.9% shareholding of VR Laser was actually owned by Salim Issa. But the 25.1%, I couldn't actually get any feedback on who owned that. And yet there was this constant reference that VR Laser was 25.1% black woman owned. On what basis? Because the evidence wasn't there.
Then if we can look at paragraph 3, that refers to the capability and how LMT was assessed to be the lowest on capability, despite the fact that the two other companies, that's DMD and VR Laser, if they were successful, would be making this type of hull for the first time. Is there anything you want to add to that? Seems to me to be clear.
Yeah, it actually defied logic as far as I was concerned, that companies that had never manufactured a platform hull were actually given a higher score on the technical evaluation. And the company that was contracted by Patria, the OEM, to make a prototype, was actually given the lowest score. And it later turned out that they had actually also relied on unrelated aspects to rate these two companies. DCD, for instance, was actually evaluated on a product that was totally different from what we had gone out on tender for, closed tender for. And VR Laser had never manufactured this hull, and it was actually given a score that was higher than the maximum. The maximum technical score that was actually supposed to be given to bidders was 45 points. And I remember seeing 50-point-something points that was given to VR Laser. And I said to myself, this is a real fuss.
Just remind me, you were now at this stage of this email at 785, you were dealing with this after the fact, in the sense that this issue had not been brought to you on time, but you got involved after it had bypassed your office.
Yeah, that is correct, Chair. In fact, if they had come to me prior to taking the decision to go out to the market, I would have said, no, you're not going to do that. We invested money in LMT for the very reason that we wanted to do well financially and technically in the execution of the Woolfeister contract. So it just didn't make sense. And what really even got me hot behind the call was the fact that the leadership at DLS was prepared to pay almost 100 million rands more than what LMT was actually quoting.
Yes, maybe Mr. Kennedy was going to deal with this later, but it might be convenient. Were you ever told what, were you ever given an explanation how this bypassed your office, or how it was not brought in your office, or why it was not brought to your office before being sent to the group CEO and it being approved?
I think the reason, this is my speculation, the reason is that they knew that I would go through this because of the value of the contract with a fine-tooth comb. And there was a very slim chance or no chance at all that I would actually approve the transaction.
But did you not ask the relevant people, how come you signed without seeing my signature on this thing? Or a question along those lines.
Well,
why was it not brought to me?
At this stage, in fact, they hadn't signed the...
Yeah?
They hadn't signed the
Or they
contract.
had not signed at that
Yeah,
stage?
this was September.
Oh,
the
okay.
contract was actually signed the following month.
Oh.
But I had no clue that the contract was going to be signed or had already been signed at that time.
Oh, okay.
Because of the exchanges that I'd had with the responsible, in fact, the person that was supposed to ultimately sign this, if it was below 200 million, was the group CEO, Mr. Riaz Saluji. That's why I made sure that he was aware of my concerns about the issues.
But now, if it was not brought to you, you were being bypassed, how did you become aware and you started sending emails? How did that happen?
It was after the meeting that we had had the night before.
You had some messaging about it.
Yeah, that was the meeting that we had, because the idea was actually to sell the approval of this transaction to me in that meeting. That was the purpose of the meeting.
Okay,
Yeah.
okay. All right, Mr. Kennedy.
Chair, may I ask for the chair's direction, please? I see it's already gone 5 o'clock and you've indicated to me you have other pressing matters to attend to.
Yes, I think let's go up to 15:15.
That's fine. Thank you, Chair.
Yes.
That will also enable us to finish this little
Yeah.
section.
Yeah, okay.
Thank you, Chair. Mr. Mlambo, just to pick up the last question raised by the Chair about not going through you, you raise a problem in that regard right at the end of your email, just before you end off with regards. You see there's an unnumbered paragraph that starts my contention. You see that?
Yes,
After paragraph 4.
I see
And I'm
that.
going to go back to that sentence in a moment. But the second line, you say, it is also worth mentioning that you flouted the delegation of authority by not presenting the file for review to me before engaging Fikile and Jan. Presumably that's Mr. Mshlontlo and Mr. Wessels.
That is correct.
Any transaction above 20 million must go through my office first. I'm beginning to have doubts that this was an oversight. What did you mean that you having doubts it was an oversight?
I actually thought that was deliberate because they knew that the submission was not going to be approved by myself or go beyond my office. And they felt that it would be better to rather lobby the group CEO to approve it without me being involved.
Okay.
There seemed to be an element of desperation of wanting to get this finalized as quickly as possible so that VR Laser would get the business.
Now, okay, if we can go back to complete the remaining portions that we haven't yet touched on. Paragraph 4 refers to triple BEE certificates again. You say, I've received evidence that the 2-week grace period for the submission of the triple BEE certificate by LMT was met, and yet you claim that, that they could not be considered as it was after the deadline. It is standard practice that a supplier that is being verified for triple BEE level cannot be penalized for that, especially if the critical data used in the assessment is readily available. What makes this even more unacceptable is that the fact that we have unhindered access to data and information at LMT. The last sentence is that again the point that because LMT is majority owned by Denel, you would have access.
That is correct, Chair.
Now, I just want you to clarify the next sentence below paragraph 4. You say, my contention is that despite being convinced of a fair and objective process that was followed by the adjudication team, let us appoint an independent assessor to corroborate your claim. Who are you referring to as the person being convinced that it was a fair and objective process? Are you talking about yourself or others?
Well, Mr. Tiebes and Mr. Berger were actually of the view that expressed that a number of times that the process was robust and fair, and I just couldn't understand that because there was no evidence when looking at the submission that this was a fair process. There are other things that I didn't include here that I should have mentioned. The engagement of one of the bidders whilst the process is still on is an absolute no-no in supply chain. If you engage any of the bidders, you engage them simultaneously, and if there are questions that are are raised, you give those answers to all of them, even those that had not raised those issues. And before the actual final approval of the transaction, they were already engaging with VR Laser on the pricing.
May I take you now to the next email, which appears at page 791. Now, this time it is not an email to Mr. Burger with copying in others
What
such as
page, 700?
791, Chair.
791, okay. Continue.
This is an email dated the 9th of September 2014, so it was a few days after the last email we saw a moment ago, correct? Just say yes if you agree.
Yes, Chair, I do.
And this time the email is addressed not to Mr. Burger or Mr. Tiebes, but to Rio Saluji, Mr. Mshlontlo and Jan Wessels, whose titles you've given us already. And am I right in saying that this you've now escalating to the top executive of Denel, the group CEO, CFO, and the COO?
That is correct.
And you say I've managed to review DLS's submissions pertaining to the above-mentioned subject. The subject above is awarding of hull manufacturing contract to VR Laser. Following issues paint an unacceptable picture from a process, fairness, and objective point of view. The tender documents were not sent to all the bidders simultaneously as per normal tender process. Then secondly, prior to the adjudication process, there were still engagements or clarification sessions with individual bidders. The process requires that such engagements be held with all bidders at the same time. Information that is requested by one of the bidders must be sent to others, even if they did not ask for it. Does this relate to the point you mentioned a moment ago, that they were being dealt with separately?
Yeah, that is correct, Chair.
Despite the fact, this is paragraph 3, despite the fact that LMT's triple BEE status was disregarded on grounds that it was still being verified, and the deadline was the 25th of June 2014, the VR laser certificate was accepted and rated on the 27th of June, 2 days after the closing date. In the submissions, you say it is claimed that LMT's quote is too low and unrealistic. The difference between LMT's quote and the VR laser quote is almost 100 million. After questioning Stefan Nell on the accuracy of his quote, that's LMT's quote, is that right?
That is correct, Chair.
He offered to come and present the facts to demonstrate it is based on realistic quotes. He claimed LMT had made the hull before under Patria's quote. And then in paragraph 5, you refer to your meeting with Stefan Burger yesterday. So was there a meeting with him on the 8th of September, which followed the earlier emails?
Yes.
You say
That's
he
correct.
indicated VR Laser had offered to reduce the quote from around 262 million to 195 million. And you put an exclamation mark. Doesn't that tell a disturbing story about the initial offer? On the basis of these findings and other facts, it is my considered opinion that the submission from DLS be rejected. Since LMT has the capability to make the hull, this issue should have been discussed before going out on tender. Good night. Now, just comment, if you would please, specifically on paragraph 5, how you found it disturbing that firstly there was about 100 million difference between the initial quotes or offers, paragraph 4, and then you're disturbed by the fact that Burger then tells you he's found that VR Laser is offering to reduce the quote from 262 million to 195 million. What was the point of, or points of concern that you had in relation to that?
In the normal business world, I can't imagine a company that is well run and it does proper costing, just simply lopping off 67 million from a 262 million quote in one fell swoop. It just didn't make sense. It means the quote was inflated in the first place. And that suggested that something anomalous was actually happening with this transaction. I can understand if the quote is reduced by 0.5% or 1%, but this is far too significant to reduce a price on.
In your view, based on procurement law and policies, was it permissible to allow tenderers such as VR Laser to change their bids in this manner?
No. The only time you accept a bid that has been reduced is when that bidder has already been approved and awarded. And once it's been awarded, then you can start the negotiations. But in this particular instance, the announcement had not even been made, and they were already negotiating. And secondly, people outside supply chain are not supposed to get involved or dabble with procurement processes. This is the terrain of the supply chain people, because they understand the process better. You cannot have everyone negotiating with suppliers. That simply messes up the process.
So if Mr. Berger was to have gone to VR Laser to negotiate with them to reduce the price, one, because he was outside of supply chain, he shouldn't do that. Two, he would have been acting in breach of policy because the policy allowed the negotiation of prices only under certain circumstances and by certain people.
Yeah, precisely, Chair.
Yes.
Yeah. This
Okay.
process had not been finalized.
Yes.
And they were already negotiating, which begs the question, was the outcome not something that was actually planned? The actual evaluation was simply to pull wool over our eyes, to give the impression that it was a fair, objective and transparent process, when it wasn't. You will actually see later in some of the emails that were exchanged, Mr. Berger himself saying that he was going to negotiate outside the normal process,
Yes, we saw
and that he
so-
was going to fight to make sure that VR Laser
Yeah, he
got
was.
the business.
Yeah, I said you would defend VR Laser. Yeah,
Yeah,
okay.
precisely. So the process lost credibility right at the outset.
Chair, may I ask one final question before
Yes.
we take the adjournment?
Yes.
Can you recall ever receiving any response from Mr. Saluji, Mr. Mshlonklo, or Mr. Wessels to this email where you raised these concerns?
I never received any response from Mr. Saluji on the issue. But what happened, there is a position paper that is in my file.
Yes.
That we actually had a meeting that was Mr. Wessels, Mr. Mhlonhlo, and myself.
I'm sorry, Mr. Mlambo, sorry to interrupt. May I suggest, subject to the guidance of the chair, that we leave that until you resume your evidence, hopefully tomorrow morning if you're available, to deal with that, because that's going to take a bit of time. And we need some detail from you on the position paper.
I'm okay with that.
You are available tomorrow to continue tomorrow.
I'll have to cancel my appointments. I don't want to be screamed at for not behaving like a good citizen.
No, we are sorry that we
Yeah.
have messed up your plans, but we appreciate it if you can rearrange and be able to continue tomorrow.
Yeah, I will certainly make myself
Yes.
available.
Okay, all right. Now, Mr. Kennedy, you and I spoke, I think yesterday and maybe last week, about the possibility that some of the days we could start at 9, and I think you indicated that you would appreciate it if we could start at 9 tomorrow.
Yes.
That was even before this situation arose,
Yes.
which has arisen that we have we took much longer with Ms. Malahlela.
Ella, yes.
But I suspect that I might not be able to start earlier than 10 tomorrow.
As you please, Chair.
But if my situation changes, I will let you know. And then maybe somebody can then advise Mr. Mlambo. And then if I'm able, then we can start at 9. But as things presently stand, I think we might not be able to start earlier than 10.
As you please, Chair.
That may or may not affect Thursday as well, but let's play it by ear.
Thank you.
And we'll see how we manage the situation in terms of the ripple effect on other witnesses.
Yes.
Yeah.
Thank you, Chair.
Okay, all right. We are going to adjourn then until tomorrow, 10 o'clock. We adjourn.
I understand. I expected